Sorry.
All right, we're good. Can everybody keep their video off until they're presenting as well? It'll help keep track of everybody. Thank you.
Okay. All right, so good evening, everyone. Welcome to the October meeting of the Brighton Zoning Board of Appeals. Thank you for attending, and also thank you to Jeff and Rick for helping us with the technical part of this so that we can again have a Zoom conference and mow through our large agenda, which is about 17 different cases that we're going to be talking about tonight. So let me again, in our other couple Zoom meetings, ask everyone to try to be concise with questions. We don't want to certainly curtail anybody's ability to say what they need to say, but try to be as succinct as possible in deference to the amount of applications that we've got to cover tonight. Okay, so let's call the meeting to order. Can you call the roll, Rick?
Did I miss something, Dennis? I had a.
Yeah, just go ahead and call the roll.
Ms. Schwartz,
Here.
Ms. Tompkins Wright,
Here.
Ms. Dale,
Here.
Mr. Mites,
Here.
Ms. Watson,
Here.
Ms. Schmidt.
Here.
Please let the record show all members are present.
Okay, Rick, just for the record, was the meeting properly advertised?
Yes, Mr. Chairman, is advertised in the Brighton Pittsburgh Post of October 1st, 2020.
Okay, very good. Okay, so we do have minutes of the August meeting. Is there any comments on those minutes?
You remember, Judy, page 25, line 24. The middle word should be slatting, S-L-A-T-T-I-N-G. Page 39, line 12. The second to last word is where, W-H-E-R-E. And that's all I have.
Okay. Anybody have anything else? Okay, how about a motion for the minutes?
So
Can I-
moved.
Second.
Okay, Andrea and then Judy.
Motion is to approve the August minutes. Ms. Schwartz,
Yes.
Ms. Tompkins Wright,
Yes.
Ms. Dale,
Yes.
Mr. Mites,
Yes.
Ms. Watson,
Yes.
Ms. Schmidt.
Yes.
Motion to approve with corrections carries.
Okay, great. Thank you very much. Okay, so Rick, is there anything you want to talk about before we actually start the applications?
Excuse me. No, not unless any of the members have any questions regarding any of the applications. I did send you over some communications today, so please keep your eye out for those. And I don't know if anybody has any questions.
Okay. All right. So I guess we'll begin with 9A0320, Rick.
Application 9A0320, application RFM Morgan Properties, owner of property located at 2125 Monroe Avenue for an area variance from section 205-12, allowing for the demolition of 2 carports, leaving the property with no covered parking spaces where 40 covered parking spaces are required by code. I'll describe an application plans on file. This application was heard at the September 2nd meeting and has been postponed to tonight.
It has been postponed?
I'm sorry. It was postponed.
Yeah, okay, I didn't think it was postponed.
Yeah, I'm sorry.
Okay.
It's on for tonight.
Okay, who do we have speaking for 90320?
David Cox with Pastoral Associates.
Hi, David. Okay, if you're ready, we're ready.
Yeah, I am. And I know you got a lot on the agenda, so I'm going to keep it short. The last time that we went before the board, there was concern with some screening to the south, to that single-family neighborhood to the south. So we went out there. We submitted some pictures of kind of what the landscaping looks like back there. And then we proposed a landscaping plan along that whole southern property line to really beef that up, evergreen type species to provide 4-season screening for the property. So that was the major thing from that. And we went out there and provided that. And then there was also a couple sections of fence that needed to be repaired. And we've called that on our site plan for those specific areas
Yes.
to be repaired.
Okay, good. So would you say that on a 12-month a year basis that this would achieve the desired result?
Absolutely.
Okay, great, great. Okay, do any of the board members have any questions? I think this is what we specifically had asked for last month.
Judy, I do have to say, I went out 3 times between our last meeting and this one. And I just have to say that the garages really were not in as sad a state as the pictures that you submitted are. They had a few things in there that normally people would want to store in a garage, because I don't think they probably have that much storage space, but much of what I saw, I think there was a grill, is the kind of thing that you would use outside. So to drag it from the inside or down in a basement or whatever and out would be kind of cumbersome, but I found them to be okay. The other thing that I did is I drove around on Newcrest, way down to the very end where the fence is. And my concern is that if those garages go down, a major portion of the fence is kind of, has space in between. And so those lights I'm concerned about coming in down the street when people are coming home and pulling into those spots. So that's still a concern, even though there may be plantings there, it's still a concern.
Okay. Is there any other questions or comments here at this point? We'll certainly go over it in the debate later. Okay. Thank you, David.
Thank you very much.
Okay. Is there anyone on the conference that would like to speak regarding this application? Okay, then there being none, then the public concern here as it relates to this application, and we're not really reviewing the Whole Foods project as a whole. What we're reviewing is a very specific issue that obviously you all see in the application that was submitted. So I would just ask that everyone would focus on issues that relate to that specifically, and I'll try to stop other kinds of discussion that really aren't relevant to this. So I would hope everyone would conform to that, and then we'll move forward. So go right ahead.
Okay. And when I said I'm the only speaker, I don't know if members of the public are going to weigh in. But
Oh, no, I understand that. I understand. Okay, but go right ahead, though.
Okay. Thank you, Mr. Chairman, members of the board. I appreciate you taking a minute to listen to us and to follow up from our discussion last month. There are 2 issues I want to talk about, but I want to begin with the one that I think is most alarming, particularly in light of the response from Mr. Boehner and the special counsel to the town. That's the issue of the cross-access easements. And I think members of the board are aware that these were required as part of the access management plan for the project. As you know, we've shown that there are multiple properties, in particular the 2 Mama San's properties, where the first mortgage holder has not consented to the issuance of that easement. And here's why this is a huge problem. In reading the letter that was prepared and submitted on behalf of the town and the developer, instead of acknowledging that this was a problem that they're going to somehow remedy, what they've done is they've told the ZBA, well, just ignore it. You can stick your head in the sand. It's not our problem if those cross-access easements aren't worth the paper that they're printed on, because we as the town don't get into that. Well, that's alarming, number one. And number two, it's totally wrong. I'll explain why it's wrong in a second, but here's why it's alarming. As I mentioned, these are required for the access management plan. One of the main concerns for this project and the portions of it are the impacts on traffic. What's probably going to happen here, because we've presented and we've shown that there's been a letter from the holder of the first mortgage on those properties saying that there's already been a default. They're going to challenge those easements, and they're either going to prevent the developer from working on the access management plan on those portions of the property, or they're going to court, they're going to go to court, and there's going to be lawsuits, and there's going to be resulting litigation anyway if this permit is affirmed and it's allowed to be issued. Here's why it's wrong. Number one, as part of the incentive zoning approval, it actually says that the town gets to review and approve the easements to make sure that they're correct and valid. And we've got evidence based on the documents that the town has provided to all of us showing that it's done so in other instances. To do so in other instances and to not do so here is the very definition of arbitrary and capricious. But that also ignores a more fundamental problem with this, which is the town has a responsibility and a duty to make sure that the developer, as the applicant for the permit, actually demonstrates that it has valid cross-access easements that will actually hold up. Where is the analysis of that? Instead, what we have are letters from the developer and letters from the town saying, well, you shouldn't pay attention to any of this. Here's the problem. Several weeks from now, maybe months from now, this is all going to blow up. And people are going to ask, well, when the town and then the ZBA after it did its independent review, did it simply just stick its head in the sand as Mr. Boehner and the developer are encouraging you to do and saying, well, it's not our problem if there's an issue or a dispute between the party that issued the easement and the first mortgage holder, we'll just have to worry about that later. People are going to wonder, why wasn't this issue addressed now? Why didn't the ZBA in its independent duty to evaluate what was done force the developer, in confirming that it complied with the law, force the developer to demonstrate that these cross-access easements are valid? Otherwise, the town special counsel and the developer are asking you to turn your head and to let this blow up later, which is essentially what's going to happen, because you've already got a letter. The town is already on notice, and it's in the record for the ZBA from the first mortgage holder saying, you can't do this. This is not valid. And it should be incumbent upon the town to require the developer to confirm that they're valid. There's nothing in there. And as I've said before, this is going to blow up in several weeks or months down the road. And I believe it is the duty of the ZBA not to simply rubber stamp and accept what has been sent to it, but to actually force the developer to confirm that it can do this. And it can't do so, which is why they took in that long detailed letter, or letters, the shorter one, much shorter one from the developer and one from the special counsel from for the town. They had all sorts of legal arguments on different issues, but on this they said, well, you can simply ignore it. I would submit that the ZBA should not do that here. And I hope that there's been no pressure put on the ZBA from the council, special counsel to the town, or from any other town officials to do anything short of its duty to independently investigate this. The second issue I wanted to mention is the issue of phased construction. So we have a building permit here that has been issued with no idea when any other building permits would be issued or any construction on other parts of the project would begin, in direct violation of the requirement for this to be single phase construction. All of the environmental review required it. It was required as part of the incentive zoning and other approvals, single phase construction. In response, the special counsel to the town and the developer has said, oh, this really is single phase construction, even though it's going to be spread out over Lord knows how long. And he said, well, you're actually confused with something that's known as segmentation. That's absolutely not true. And those of you who are on the board who are familiar with seeker and segmentation know that that's not what this is. Segmentation is when somebody reveals only a tiny portion of the project and gets an approval for that. So they don't have to do an environmental review for the project as a whole. That's not what's going on here. What's going on here is that a single building permit for one of the 5 structures on the property has been issued, allowing for the construction to go in phases. And to give you a sense of what was expected to be a reasonable construction timeline, Brighton Grassroots submitted an affidavit to you, and I would encourage you to take a look at it, where it contemplated that all the building permits would be issued within 2 months of each other, and that all of the construction would be completed on all 5 buildings within 2 months of each other. I ask you this, is the process that's being approved now at the planning level, is that going to allow for all the permits to be issued within 2 months of each other? The answer to that is no, because it's already been well over 2 months since this permit was issued. Is this contemplating completion of construction within 2 months of each other? Absolutely not. We're talking about permitting and construction that is going to stretch out now over years. That is phased, multi-phase, phased construction. This is not single-phase construction. This was supposed to be done as a single phase because that was the impact that was actually studied. You know, the interesting thing is why this happened in the first place, and I think it's fairly obvious. The developer can't build any of the other buildings because they're too close to the Auburn Trail, which is under litigation, which probably isn't going to be resolved anytime soon. And there's probably going to be appeals. And there's all sorts of other litigation regarding the project. So the developer, it appears to me, was desperate to try to get something going and something built. And the town, for whatever reason, acquiesced to that. In doing so, what they have done is they have greenlit construction to occur over a period of years, not within a period of 2 months, which is what was clearly contemplated. This is not single-phase construction. By the special counsel's definition, single-phase construction could last over 10 years. How is that single-phase construction? It's not. They're trying to dress this up and scour the record and the other approvals to try to shoehorn this in and say, well, we contemplated doing different things, you know, at different times, but as all part of one process. Well, again, I would encourage you to look at the schedule that had been proposed that's attached to Brighton Grassroots submission from earlier this week. 2 months. We're nowhere near that. And we're nowhere near that because they're trying to hurry up and get something built because they know they can't do anything on the rest of the properties because of all the litigation. So with that, I thank you for your time. I do appreciate it. And if there are any questions you'd like me to answer, I'm happy to do so. I do see some others who are appearing here that may say something in opposition, and I would just ask if something comes up that I hadn't already addressed that I might have an opportunity to respond if needed. Thank you.
Okay, so let's start with the board members. Jeannie, do you have anything?
Yeah, I do. Thank you, Mr. Chairman. I do have a couple of questions. So one of the things stated had references to traffic. And so my first question is, how will the issuance of the building permit itself for the Starbucks, how would that increase traffic accidents?
Well, it depends on what's done with respect to construction there, number one. But number two, the key here is the access management plan. Okay, they can't proceed with that if they don't have the permission, if they don't have actual valid easements. And the whole idea was this was tied to the issuance of the permit. It was part of the incentive zoning approval. And what's going to happen is when they try to actually implement that and construct that, they're not going to be able to because the first mortgage holder is going to stop them. He's actually, he's already issued a notice saying that there was a default. Okay,
well, let me try to ask this in a slightly different way then.
Yeah.
So given the nature of the surrounding property uses, hotels and restaurants, how will the issuance of the building permit for the Starbucks detrimentally or noticeably increase traffic to and around the project area and the adjacent neighborhoods?
The issuance of the permit alone? Well,
yeah.
It would depend on what vehicles are coming and going on the property. And it would also depend, it would certainly delay the absence of a valid easement would delay the developer from implementing the access management plan, which was designed to mitigate traffic problems there. I guess what I'm saying is if you begin the process of construction and building without ensuring, as was required under the incentive zoning approval, to make sure that the access management plan is also underway, then it's going to cause huge problems.
Okay. Okay. So again, we're talking about, the surrounding properties.
Yep.
And the nature of those surrounding properties, we're talking about, restaurants, hotels and the like. So how would the issuance of the building permits for Starbucks, how would that detrimentally or noticeably decrease the appellant's ability or the ability of their customers to safely and conveniently access the various businesses or homes?
It would depend on the circumstances. It would depend on the vehicles that are coming onto the site, that are allowed to come onto the site. It would depend on what they're doing with construction. I don't know this. I don't have a specific answer to you, but what I'm saying is it would depend on the circumstances. And also what I'm arguing is also that it's going to affect the access management plan. They cannot carry out the access management plan, which was part of the incentive zoning approval.
Okay.
This is Member Wright. I just wanted to interject something and just kind of along as we're talking about these access easements and what town personnel is required to do to confirm that these are valid. How far, say, is their would you argue that it's their responsibility? Do they have to pull a title report and look for any mortgages on the property? Do they have to pull an organizational chart from the company and see who has signatory authority to confirm who signed the easement? I mean, where's the line that you think that they have to fulfill their requirements but don't have to go over?
Well, I think that's a fair question, but I want to point out what's actually occurred here, which is this. The town actually has a letter from the first mortgage holder here. So it's not as though we're, look, I may have an opinion on the due diligence that the developer should have to do, but that's not even the question of the issue here. The question of the issue is you actually have knowledge of this problem, and the developer has not demonstrated that it's actually resolved this particular problem, which was the one that we raised in our papers. So I would say this, that the line at minimum is where the town and the ZBA have actual knowledge of a specific issue here, right? Where you have the first mortgage holder reaching out and issuing a default on these, and that comes to your attention. I would say that you can't do what the special counsel to the town and the developer are asking you to do, which is stick your head in the sand and say, well, it's their problem. I would say in an instance where you have somebody affirmatively raising something to you, that the board has a duty to require the developer to confirm that it can do this. And in this case, it can't. And the reason we know it can't is it would have said otherwise in those long detailed papers if it could. Instead, the best it could come up with is, look, you don't really have to pay attention to this. And you know what? When this blows up later and causes huge problems, everybody's probably going to be asking why.
So the argument isn't that it shouldn't have issued that permit when it issued it, because at the time it issued, it was a valid easement reported that appeared on its face to be, perfectly properly issued by the property owner, and at least enforceable against the property owner and likely any future purchasers of the property. Your argument is that months later, when they got a letter from a mortgage holder, that's when they should reverse the decision. Not that it was issued improperly when it was issued.
Well, I don't think it was months later, but my point is that when there is specific knowledge of this problem, that the town cannot simply stick its head in the sand. And number one. Number two, it has a general duty to confirm that the developer has complied with all of the laws, including those pertaining to incentive zoning and the incentive zoning approval. Number three, the incentive zoning approval actually says that the town gets to review and approve the easements. And I know that the developer was aware of this issue. And so the developer, maybe you should ask the developer why it handed this to the town, knowing that there was this issue and knowing that there's a first mortgage holder out there.
Okay. Andrea, do you have other questions?
Yeah, this kind of relates to some of what at the last meeting, though not so much as the arguments you're presenting tonight. But there were some safety concerns presented. One, there was concerns regarding, construction fencing brought up by one of the towns. I think it was one of the towns, members of the town, and just general safety concerns in general with issuing of the building permit, both generally and for just the Starbucks building. Is the applicant arguing that there are safety concerns with issuing of these building permits, specifically Starbucks, the whole permit, or with a fencing issue?
I think some of that had been raised actually by Brighton Grassroots.
Okay.
Not so, but certainly we would join in anything they said, but I wouldn't have anything specific to say on that beyond what had already been submitted.
Okay. And just one quick question about timing. I have seen the timeline, what Brighton Grassroots argues was the timeline, but certainly in this environment, we would anticipate that a timeline might get stretched a little bit. Is there a timeline that you think would be appropriate for it to not be considered, or for your client would consider an appropriate timeline for it not to be considered phased construction, it just be a process of construction?
Well,
So
at the risk of answering your question with another question, I think the more appropriate question for the developer is, what's the timeline for the other buildings? And I think the answer you're going to get is, well, we don't know because it's all tied up. And it's probably going to take several years, even if they're successful in all of the litigations. And my point is only this, in a roundabout way of answering your question, is, of course, this is going to be phased because it's going to occur at different times over a period of years.
Anything else, Andrea? Okay. Kathy, do you have anything?
I do. Just a few questions. And first, thank you for coming and expressing this, because it has helped me understand the papers a little bit better. While you didn't focus it on as much in the papers, there's a lot of talk about harm to the various groups if this building permit is allowed to go through. Could you talk to me a little bit about the harm that you and your group will be experiencing versus the general public?
Sure. Based on their proximity to the project, well, I'll give you a perfect example with respect to the phased construction. One of the issues with respect to Seeker, for example, is they review and determine what the impacts of the project are going to be. And one of the things they talked about to impact or to mitigate the impacts of the project was construction in a single phase. It literally says that inside the review and the approvals. If this approval is allowed to occur, if these permits and the building is allowed to occur in multiple phases, the impacts of those construction, particularly for businesses and residents that live nearby, okay, the impacts of those are going to be different and more significant than the impacts that were already contemplated under the reviews. That's one example I can give you.
And can you let me know, are you arguing that this harm because of the phasing somehow affects your group in particular, or are you talking about kind of just generally Brighton residents driving down Monroe Avenue and Clover?
Specific to the individuals and businesses in close proximity to the site of the project. I mean, just construction alone is disruptive.
To the average person driving down Monroe, the business owners on Monroe.
Well, I mean, I can give you a general example. If there's any kind of disruption in traffic or whatnot, it can affect the adjoining businesses. It can affect the residents living nearby, and these are certainly close enough to be within the sufficient proximity in the zone of interest.
And has your group done any study? I'm just trying to find out if we know for sure that this is going to happen, or if this is something you just feel is going to happen.
Well, I mean, I'm not sure what you mean.
Is there something that, is what you're looking, the harm regarding this, if it was done in what you say in these phases over time? Do you
Well,
have anything substantive that shows that this really will create a harm?
Respectfully, the study was done by the town and the developer under seeker about the impacts of it, and acknowledged that multi-phase construction would have impacts. And the way to mitigate those impacts was to have construction in a single phase. So I mean, respectfully, that's already been decided.
Mm-hmm. And you were talking about the issue with regard to the not having a signature of the first mortgage holder. And I was going through all the papers last week and then this week again and then today, and I was trying to find something that said that you had to have the signature of the first mortgage holder. Do you have anything that says that that is a requirement?
Sure. Well, we have the letter from the first mortgage holder, and I believe it's a contractual requirement for them to have that permission, and they don't have it. And again, the town's been notified of this. You know, this isn't an instance where this is something that has just been randomly picked. The town is actually on notice about this.
Mm-hmm. Mm-hmm.
Okay.
And it's on notice that the first mortgage holder is going to exercise those rights.
Okay.
Okay, thank you.
All right, Kathy, thank you. Judy, do you have anything?
No, I was just kind of looking at the chart that has been sent out by the town about, you know, what we're talking about, the cross easements. So you feel that the mortgage holders are relevant with respect to issuing the building permit and the cross access easements. And also you feel that the things are not sufficient to implement and construct the AMP. Is that a fair summary of what?
Yeah, I think that's fair.
Okay.
Okay. All right. Jen, do you have anything?
I'm trying to sort things out. Sometimes the word the project is being used, and I'm just curious if you could define what you mean by the project. Are we specifically talking about the permit for Starbucks here?
Well, so yes, when I'm talking about these issues, I'm talking about these issues that I've raised with respect to the Starbucks permit, which is what is before the ZBA. When I'm talking about the project, I'm talking about the overall construction of the project, because it is supposed to be single phase construction. And that's why I'm referring to the project generally. And I would respectfully submit that in issuing the building permit under the time frame and what's complicated here, or what's contemplated here just for the Starbucks, that's clearly indicative of a multi-phase construction for the entire project, if that makes sense.
It does, yeah. And my only other question has to do with I'm wondering, how does the issuance of the permit for the Starbucks specifically interfere with the use of the Auburn Trail, or does it?
You know, that's a good question. I think that's a little bit different. What really the issue is, I think that property or that portion of the project is probably the furthest from the Auburn Trail on the site. But what we're saying is that they can't build the other buildings right now. They can't move forward around the rest of the plaza because all of that is tied up in litigation. So I think the idea here was, and I think it's fairly obvious, that the developer comes to the town and says, we need to get something going. We need to get one of these built. And the town goes, okay, well, you know, maybe this one isn't as tied up or isn't as difficult, and so we'll let you do this one. But the problem is the end result of that is multi-phase or phased construction as opposed to a single phase, because nobody can give you a timeline. Certainly not a timeline of completion within 2 months, right? Which is what was contemplated. Nobody can give you that timeline for the rest of the buildings on site. And the rest of the buildings on site will be constructed over various times, resulting in impacts, right, of construction over and over and over again in phases, as opposed to what was considered and what was approved, which was single phase construction to mitigate the impacts of the project.
Good. Anything else, Jen?
Go ahead, Andrea.
Just real quick, in your submittals, there were also objections based on failure to get a letter of credit, failure to get New York State DOT permits. You haven't mentioned those tonight. Are you satisfied with the response to those, or are you maintaining your objections to those issues as well?
We would only maintain objections to the extent that there would be problems with them, but we have been told subsequently that the letter of credit had been provided and shown that. We raised that, though, I want you to know we raised that in good faith because, as you probably saw, the town was required to turn over, essentially the entire file to us. And, we all went through it, and that letter of credit was not in the file, and it was supposed to be everything related to it. So that's why we brought the claim. Now, to the extent they've demonstrated to you that the letter of credit exists, and I think we've seen something, obviously we wouldn't pursue that anymore. And what was the other, the DOT approval? My understanding is that that did come, or something to that effect came after the permit was issued, although it did in fact come.
Okay. All right, Jen, did you have anything else? No?
So I have a couple questions.
Okay, David.
Yeah, so is the Starbucks property exempt from the litigation in some way? Not involved in the litigation?
No, it should not. That's not true. I think that there was a calculation that maybe because this was the farthest from the trail, that this would be the easiest to do. And also, I think they probably want to open it quicker because next to the Whole Foods, this is probably going to be the highest volume generator of traffic for the property.
So, but then I don't understand that I mean, it seems to me that your argument that they can't continue to pull permits and do this in a short period of time is because the rest of the property is tied up in litigation. And I don't see that argument when this is involved in the litigation and they're pulling a permit on this one.
Well,
How do you explain that?
Well,
I mean, you're conjecturing that it's necessarily phased because there's, quote, litigation involving the rest of the property. It seems to me the litigation is on this property too, and they're not phasing on this property. They're going ahead.
Well, I'm curious as to what's going on, with the other properties, because we don't see any indication of any movement toward a permit on the other properties or construction on the properties. And I think, candidly, that speaks for itself. I mean,
but
we can.
Clearly, the litigation isn't a complete impediment because we're doing it on this one, right? So my other question is, I'm not sure that how you can imply, again, and kind of in the same vein, kind of imply from the issuance of this permit a sequence. I mean, we really don't know. It's conjecture, and I'm not sure. It's just conjecture of where the next permit is going to be issued and such that creates an idea that it might be phased or whatever. But all we have really in front of us now, correct, is just this permit, right?
Well, that's correct, but this permit cannot be issued in the sense that the project cannot be constructed in phases, and this permit would allow that to happen. And
but why? That's my question. I mean, are you suggesting that we have to issue all the permits for all the buildings at once?
No, not at the same exact time, but I think the estimate from Brighton Grassroots on what would be considered single phase construction in terms of permit approval and completion was within a couple months of each other. And I think that gives a fairly good guidepost as to what was actually, contemplated. What we have here, respectfully, I don't think is conjecture. We have so little idea of when the other buildings are going to be built that they're not even talking about when that's going to occur. We're talking years down the road. Otherwise, they would have rolled this together, and they haven't done that. They are trying desperately to get something built on the property. I would probably do the same thing if I were in their shoes. It certainly makes sense. I can understand why the town would want to show some momentum on it. I think maybe it's even well-intentioned, but it's not legal the way they're doing it. And
but other than the arguments that you're making today, I mean, are there legal impediments to them pulling a building permit for one of the other buildings? I mean, other than the ones that you're presenting tonight, is there some further legal impediment that doesn't allow them to pull a permit for another building?
Well, there's legal and there's practical. Obviously, legally, they would have to comply with all the requirements of the incentive zoning approval, et cetera. But there's also an issue of financing to pull the permits. And my sense is they would have significant trouble getting financing for the construction of the whole project, right? While all of these lawsuits are pending. And so you go back and you ask yourself again, why are we doing this, just this one building here that maybe can generate enough traffic and revenue, at least to give us some money, you know, to keep going. I mean, look, I think everybody can sort of sense what's truly going on here. And I think the reason why the response from the town special counsel was so long is because they're concerned that we've raised very serious issues. And, you know, I've said this at the beginning, and I'll say it again. I believe it is incumbent upon this board to not only review what was done de novo, anew, as though you're doing it for the first time, but to force the developer to confirm that it's going to comply with the law and have the ability to do this, including the fact that those cross-access easements are actually valid.
Well, with respect to the cross-access easements, so the grant of the easement is just like a deed, right? I mean, it is transfer of an interest in a real property, correct? And I'm just not clear on how you can argue that. So if I buy somebody's piece of property and it has a mortgage on it, my conveyance is somehow illegal or not effective, or just because you transfer a property that has a mortgage on it, and an easement is no different than a deed.
But
if I transfer my deed to you and it has a mortgage on it, I don't see how that makes my transfer of my deed. You know, I transfer my house to Andrea. I don't see where the fact that it has a mortgage somehow vitiates the fact that I gave her the deed and she now owns my house.
Because in this instance, they do not have the legal contractual authority to actually do that conveyance without the approval. And that's what was indicated in the letter that the town is aware of and had notice of.
Yeah,
that
would be correct. I mean, there's no question that that's a violation of their agreement. But it doesn't, I mean, if I have a right of first refusal on my property and I sell it to Andrea, and that violates that right of first refusal, which I'm supposed to go and give my neighbor the opportunity to buy the property first, that doesn't make my deed to Andrea any less effective. So I'm just not, it seems to me that, you know, I guess my question is, how do you respond to the fact that, you know, it really is a contingent interest, that the deed is effective as of the date of the delivery, and the fact that those easements have mortgages, it could be, it doesn't vitiate I can drive down these easements, right?
They can foreclose and extinguish it.
Of course, that's true in every instance, but I can still drive down these easements, right? Is anybody, you know, I can drive down the easements. In fact, no one can anybody prevent me? Andrea gives me an easement next to my street. I'm going up and down that easement. I mean, is it somehow someone can prevent me from doing that?
Respectfully, sir. Well, yes, but respectfully, sir, here's the problem. This can be foreclosed on. We've already had notice of a default. And this is what I'm talking about when this is going to blow up and they actually don't have valid easements. When I think I said a month ago, they're not going to be worth the paper they're printed on. That's what I mean. And it should, you know, I understand maybe I sense a little frustration on the part of the town saying, well, gosh, we have to confirm this and we have to confirm that. And I think board member Wright was getting at that, right, when she was asking about that. But what I would submit to you is it shouldn't be the burden on the town. The burden on the town should be to put the developer through the paces to confirm that all of this is kosher. And here it's not. You know, that's the bottom line.
Thanks.
Okay. David, are you set?
Yeah, all set. Thanks.
Okay, great.
Thank you.
Okay, is there any of the board members or staff that want to talk any more about this application at this point? Okay. All right. So then at this point, then let's see who in the Zoom audience of virtual reality here would like to speak related to this application. So please make your feelings known if you would like to.
Yes, I think Mr. Boehner would like to speak.
Okay.
Good evening. I'm Ramsey Boehner, town planner. In attendance with me tonight is Mike Ion, Commissioner of Public Works, and John Mancuso of the law firm of Weaver, Mancuso in Brighton. Chairman, in order to avoid duplication of our presentation of my responses to the allegations made in this application, in the application 10A0220, I respectfully request that we have the opportunity to respond to both appeals during the hearing of 10A0220. Do you have a problem with that?
No, only from the perspective that if you feel that the comments are relevant to both, as you can see, they're two separate applications, so we cannot hear them together. But if you want to do it that way and speak during 10A02, that's fine.
Both they raised very similar comments from what I could see.
Yes. In deference to time, that would be fine.
Okay.
So are you holding at this point then?
Yes, we will hold to later.
Okay, okay, that's great. Okay, all right, so who else would like to speak regarding this application?
Mr. Rosenbaum?
Yes, this is Warren Rosenbaum. Good evening, ladies and gentlemen of the Zoning Board of Appeals. I thank you for allowing me to make some comments. I'm a member of the firm of Woods Oviatt Gilman, and we represent the developer with respect to these appeals. We have received the letter from Mr. Boehner and all these attachments to the letter, and we find it to be very thorough and well reasoned. And as I indicated in my most recent letter to the board, we concur in all respects with Mr. Boehner's position concerning the legality and the correctness of the issuance of the building permit for the Starbucks. There are 2 points that I wanted to emphasize, some of which Mr. Sakin has touched upon and some of which were raised by comments from members of the board or the staff. The first thing is I wanted to address the question of the trail easements. I listened to what Mr. Dollinger had to say, the zoning board's attorney, and I completely agree with what Mr. Dollinger is saying. That is those cross access easements are completely valid. There is nothing that Mr. Sakin has said either in his oral submissions or in the written submissions made by Mr. Sakin on behalf of his client, Save Monroe, including the lack of any legal authority that would vitiate or call into question the validity of those easements. Nobody is challenging the fact that the easements were granted by the actual owners of the property, that they had absolute right under law to grant rights to their property. Nobody's raised the question as to the content and the recording of those easements, and the town was rightly satisfied to receive them and accept them. Everything else that Mr. Sakin has to say with respect to those easements is speculation as to what may or may not happen in the future. And the town was correct in following the procedure that it adopted and accepted those easements. So for those reasons and the legal authorities cited both in Mr. Boehner's letter and in my letter, we would respectfully request the board to deny that aspect of Save Monroe's appeal. The other thing I wanted to talk about is the trail easements from RG&E. I didn't hear Mr. Sakin address those in particular on his oral presentation, but there was a question raised concerning the amenity agreement and whether or not it was necessary for the developer to obtain recorded easements from RG&E for the trail before any building permits were issued. And we agree with Mr. Boehner's presentation that the amenity agreements did not require that the easements be recorded prior to the issuance of a building permit, and the town rightfully issued the building permit for Starbucks. I want to address one thing in particular that Mr. Sakin mentioned that I wasn't planning on talking about until Mr. Sakin raised the issue. Mr. Sakin has argued that this project, in effect, is taking place in multiple phases. And what he's pointing to is that a building permit was issued for Starbucks, but no other building permits have been issued. And he argues that he concedes that the reason that the other building permits have not been issued and perhaps the developer has not applied for these other building permits is because of the incessant litigation
that his client has commenced, his client in BGR has commenced against the developer. So what he's saying is that you're not building this project fast enough. And the reason you're not building this project fast enough is because of all the litigation we brought against you. So so SMA's Save Monroe is basically creating a catch-22 for us. The builder would love to be able to pull building permits for all the rest of the buildings in the project and obtain whatever financing the developer might need for that purpose. But as Mr. Sakin readily acknowledges, that's become problematic because of the litigation his client has commenced and others. So Mr. Sakin and his client cannot create their own dilemma that they've created for the developer. So we would ask the board to disregard that argument because they should not allow these litigants to create a catch-22 for the builder. I think the town recognized the dilemma that this litigation has created, we asked the board to affirm Mr. Boehner's determinations, the issuance of the Starbucks building permit, and in all respects deny the appeal from Save Monroe. That's all I have to say unless there's a question.
Okay, thank you, Mr. Rosenbaum. Okay, is there anyone else that would like to speak, please? Okay, Mr. Zoglin there, I guess is.
Hello, this is Jacob Zoglin. I represent Brighton Grassroots. I'll be speaking on the next the BGR appeal. And I would just like to say that we support SMA in their appeal. And I'll save my comments, which also relate to SMA's appeal until then, just as Mr. Boehner is doing.
Okay, that'd be great. Thank you very much. That helps in deference of time here. Okay, thank you. Is there anyone else that would like to speak, please, regarding 9A0420?
Yes, my name's Danny Daniele.
Hi, Dan. Go right ahead.
Just quickly, I want to add the gentleman, I forget his name, from Buffalo representing the opposition, Mr. Sakin mentioned that we're phasing the project and that we've only received the building permit for Starbucks. Obviously, they're trying to paint a picture of just Starbucks. What they don't want to tell you is the whole truth, which is unfortunate, and that's why I decided to come on. If they were to take the time to look at that first permit, they'll see that it's the building for Starbucks, but more importantly, it's a permit to do the entire site work for the full 10 acres of the parcel, which includes well over $4 million worth of site work, which is a process that takes about 6 to 7 months. And because of COVID and because of the weather and everything else, obviously that's going to take some more time. The site work is probably the most difficult part of the project, of which we've taken a considerable chunk out of that so far. Once we're complete with the site work, putting up the other buildings literally takes less than 90 days. Of course, the gentleman from Buffalo doesn't understand as much perhaps as we do with construction. Site work is the larger chunk of that. And the fact that he keeps on saying that we're phasing this project, just like anything else we do in our life, there might be different steps to getting the project done, but it is far from being phased. And although the gentleman from Buffalo is saying that he has no idea when this project is going to get done, our hope is to have the entire project complete by summer of next year. And we have, contrary to the gentleman from Buffalo who mentioned that he doesn't know if we have financing, or he doesn't think that we can get financing, we have full financing on the whole project. Some of you may recall a few months ago, Wegmans was forced to make a statement that they're funding the opposition. And Mr. Sakin earlier said, I think your words, Mr. Sakin, were, I think we can all sense what's really going on here. And I think what we can sense that's really going on here is that we have multiple attorneys from Buffalo being represented from contributions from Wegmans, who obviously doesn't want another grocery store in Rochester. And what their job is, and they're doing a great job at it in fairness, is to pick apart every aspect of this project to delay it as much as they can, hoping that either the developer will give up or that the developer won't get financing. And unfortunately for them, that hasn't been the fact. There are a tremendous amount of people in Rochester, specifically in Brighton, that are very frustrated with the process that's commenced by this opposition and what Wegmans has done. And they are also helping back us this project. So frankly, we have more backing on this project than any other project we've had before. And just to reconfirm, the process will continue. It hasn't been delayed other than the delays that we've received from this opposition group. And we continue to move forward, and we will do that. The Auburn Trail, the second portion of it is almost done. So residents will have that second option to use either trail. Hopefully we'll be able to get that open in the next week or two, believe it or not. The AMP, which is what he's talking about across the street, we're hoping to start construction on that momentarily. I frankly have spoken with the mortgage holders that Mr. Sakin talks about, who wants to foreclose and this, that, the other. They may want to foreclose. I don't know the details of that. I haven't seen the letter. They may foreclose on the person who owns the property who's not paying them, but I can confirm that they absolutely would love to see this project across the street, Whole Foods, go forward, because they understand that the value of their property will more than double. And the very aspect of having those easements on their property, frankly, double the value of their properties now that they'll have access to a traffic light, which would finally allow pedestrians and vehicles to make a controlled access left-hand turn in and out of those properties, which never existed before. They've told me word for word that this was probably the best thing that could have happened to their property. So although Mr. Sakin might try and give you fear that they might foreclose on the project and this, that, and the other, there's nothing they want more than to have those easements. The gentleman that they've spoke to is also friends with Howie Jacobson and the Wegmans Group, and I think he was asked to write. I doubt he wrote that letter. I'm sure someone wrote it for him. But his comments directly to me was, I don't want to be the one stepping in front of this project. I'd love to see it go forward, and anything I can do to help, please let me know.
All right. I appreciate your comments, sir. Thank you very much.
You're welcome.
Okay. Who else do we have that would like to speak regarding this application? Okay. And very good. Okay. So I think we can close the public hearing at this point and move on to the next application. Thank you very much. Go ahead, Rick, when you're ready.
Application 10A0120, application of Catherine Solano, owner of property located at 4 Cardiff Park, for an area variance in section 207-10E5 to allow a driveway expansion to be 2.8 feet from a side lot line in lieu of the minimum 4 feet required by code. I'll describe an application and plans on file.
Okay, and who do we have for this application?
Hi, my name is Kate Solano, and I want to start by thanking the board for reviewing my application and for giving me time to speak this evening.
Okay.
Okay.
Please proceed.
Yep, so it's very, very straightforward, very simple. I have asked the board to expand my driveway to allow for 2 cars to be parked side by side. But in order to do that with the minimum width needed for those 2 cars side by side, I would be encroaching slightly in on the 4-foot code, which is required between the edge of the driveway and the adjacent neighbor's property line. So the edge of my driveway would be actually 2.8 feet from the adjacent property line of 12 Cardiff Park. I have received support from the owners of 12 Cardiff Park, and they have signed an affidavit of support that was submitted with the application for the variance. And also with the affidavit of support, there was support from many other neighbors in the Rollingswood mini neighborhood that we have here. And that's pretty much the extent of it. In regards to the aesthetics of the expansion of the driveway, we are the last house on the dead end of Cardiff Park, and directly to the right of where our driveway is, if you're facing the front of my house, there are hedges that are owned by 12 Cardiff Park, and they're about 5 feet tall, so they visually block the cars when they're parked in the driveway. So aesthetically, it wouldn't make a difference to the neighborhood. It would look the same.
Okay, very good. I appreciate your comments. Board members, questions for Ms. Solano?
Just so that it's on the record, the reason you can't expand on the other side is because of the location of your front door and your access into the home.
Yeah, Yes, that's exactly right. Where the front steps are and the front porch, it's very, very close. It butts up almost directly to where the edge of the driveway is.
Okay.
Any concerns about runoff of water with the expanded amount of asphalt right next to the neighbor's property line?
Actually,
Closer to the neighbor's.
So that's an excellent question. We actually believe that we're actually making a positive impact on the environment by doing this, as there tends to be a lot of collected water in that area where the bushes are. It's kind of like a low base. So in the spring and whenever there's heavy rains, there is a lot of pooling water there and a lot of mud. So by putting the extended gravel, it's actually improving environmentally the space.
Okay. All right, board members, questions?
I have one.
Sure.
Just, will this be a gravel driveway or an asphalt driveway?
So as of right now, we are going to do the gravel with the full intent in the spring to put in a new permit request to repave, because we need to remove the existing driveway because it's in poor condition as well.
Okay. All right. Other questions? Okay, very good. Thank you very much. Appreciate it. Is there anyone in the audience? I'll be okay here. Is there anyone in the virtual world that would like to speak related to this application? Okay, there being none, then the public hearing is closed.
Thank you.
Thank you.
Application 10A0220, application of Brighton Grassroots, appealing the issuance of a building permit by the Town of Brighton Building Inspector to the Daniele Family Companies, developer of the Whole Foods Plaza project located at 2740, 2750 Monroe Avenue. Also described an application and plans on file. Mr. Chairman, I would just like to, for the record, the applicant amended their application and has submitted 2 supplemental affirmations well past the application cutoff date for this meeting. I suggest we receive and file that material tonight, and I will then distribute it to the members.
That sounds reasonable, so proceed with that. Okay, and who do we have speaking for 10A0220 tonight?
Good evening, members of the board. My name is Jacob Zoglin. I introduced myself earlier with respect to the SMA application. I'm an attorney with the Zoglin Group, and I represent Brighton Grassroots LLC in this appeal. I'm going to give a little bit of a background on some of the injuries to Brighton Grassroots that'll come from this in order to respond to some of the questions that came up in the SMA application. So as I laid out in the paper submitted to the board, BGR's members live in close proximity to the site of the Whole Foods Plaza project. And because of that close proximity, they will be adversely impacted by this project in ways that are different from how the public at large will be impacted. Many of those harms relate to the adverse traffic impacts, because as the developer admitted during the reviews for this project at the town board and planning board level, this project is going to draw unprecedented levels of traffic to the area. And as traffic engineers found during the town board and planning board reviews, this project will substantially create substantially more traffic along the stretch of Monroe Avenue, which already has some of the worst traffic in the town and which has failing grades from the State Department of Transportation. Concerns about traffic and parking were one of the most significant issues before the town when this project was initially considered, which is why the town board and the planning board approvals expressly required the implementation of an access management plan, or an AMP. The access management plan was supposed to funnel traffic to the stoplight, allow for the sharing of access and parking between the north and south sides of Monroe Avenue, and mitigate the adverse impacts that the traffic was already going to cause. So they determined there was going to be a lot of extra traffic, so they said, you need to come up with something that will reduce the negative impacts of all that traffic. The AMP was their mitigation for those traffic impacts. Now, before I begin discussing the remaining details of our appeal, I'd like to take a minute to discuss some of the issues of how we got here. It's been particularly difficult because the town board and planning board have not been very forthcoming with information about this project, which has led to some concerns, which I'm sure you've seen in the media and from members of the public, about transparency. And that has reinforced the impression that the developer is getting some kind of special treatment. So when this application was under review, the town refused to disclose whether the developer had applied for the building permit that we're talking about here, and refused to provide those documents that form the basis of the application until a judge ordered them to do so. Then, the town failed to provide several of the documents related to this building permit by the court-ordered deadline. As a result, we've kind of been working with one hand tied behind our back here. We've had to supplement the appeal multiple times based on newly obtained evidence because of the drip, drip, drip that we got from the town. And then even after we filed the appeal, the town continued to hide information from project opponents. And both the town and the developer, when they submitted oppositions to these appeals, failed to CC BGR on those applications. I mean, we're the applicant. We should at least get the submissions from the town and from the developer that purport to oppose our appeal. So that brings us to where we are tonight, to this hearing. As you know, on an appeal like this, the ZBA's review of the building inspector's decision is de novo, meaning the ZBA stands in the shoes of the building inspector and can make any decision the building inspector could have made. The ZBA doesn't owe any deference to the building inspector's decision. It gets to make its own decision. So you may consider whether the developer's application for the building permit complied with the town code, complied with the town board's incentive zoning resolution for this project, complied with the planning board site plan approval resolution, and whether it complied with the town board and planning board seeker findings. And importantly, if any of those authorities directed you to consider other issues, you have the power and the duty to consider those too. So my focus today will be on 4 issues raised in the appeal. The first 3 relate to prerequisites for the project that were not satisfied, and therefore render the building permit illegal. Those prerequisites come in the form of the town code and the various approvals I mentioned before, and they're laid out in detail in our papers. The 3 prerequisites that render this, that were not satisfied and which render the building permit illegal are: 1, the invalid cross-access easements for the AMP; 2, the building inspector's failure to certify on each site plan that the project complies with the town's comprehensive development regulations, i.e. the zoning code; and 3, the developer's failure to obtain all state and local approvals, which is I believe it's a condition of the planning board site plan approval. I want to say 41, but it's in the papers. And among those state and local approvals which were not provided include state legislative approval under the public trust doctrine and local resident approval in the form of a permissive referendum as required by New York State Town Law, Section 64. The last issue, the 4th issue, relates to express prohibitions that the town violated by issuing the permit. So the permit does something that the law expressly prohibits them from doing. At the earliest stages of reviewing this project, the developer asserted in its full environmental assessment form under seeker that the project would be constructed in a single build phase. The town board approved the project to be constructed in a single build phase, and both the town boards and the planning board seeker finding statement for the project assessed and approved only construction in a single build phase. So the 4th issue that I will address demonstrates that the building permit is illegal because it authorizes construction of the project in multiple phases, as Mr. Sakin discussed with you, even though the approvals for the project expressly prohibit multi-phase construction of the project. I'm going to address each of these one by one. So first, the cross-access easements for the AMP. As you know, the incentive zoning resolution requires the developer to implement an access management plan. The developer has to create a common rear access drive behind the plaza, the plaza across the street from the project, in order to funnel traffic from the plaza on the south side of the street to a single point that would allow it to interfere less with the additional traffic generated by the project. In other words, the AMP was crucial to the incentive zoning resolution and amenity agreement because it helped address one of the major concerns of the project, the severe adverse traffic impacts. And so the town board expressly made implementation of the AMP a condition of approval, and therefore a precondition to issuance of the building permit. Essentially, the AMP works by allowing traffic to move between the various properties on the south side and the north side of Monroe Avenue. So if the developer and the owners of the AMP properties don't give each other those mutual rights to drive across and park on those properties, or if those rights can easily be cut off or terminated, the access management plan fails. And what we're talking about when we're talking about the access management plan failing is that it's incapable of mitigating the adverse traffic impacts from the project, the ones that traffic engineers said were going to come, and the ones that the developer said, look, we're going to have unprecedented levels of traffic. Well, the access management plan will make it so that those adverse traffic impacts are worse. That's why the access easements are so important. It's because they are what make the access management plan work. Now, the cross-access easements that the developer submitted in an attempt to satisfy this condition are legally insufficient because the recorded easements for 2799 and 2735 Monroe Avenue do not include the consent of the first mortgage holders, as required by the underlying mortgage. So if you look at Exhibit D of our submissions, you'll see at paragraph 1.11a of the Mama San's mortgage, there is a clause that wherein Mama San's gave up its right to grant easements or encumbrances of the property without the consent of the first mortgage holder. And so as a result, any conveyance of the cross-access easement or any easement or interest in property over the Mama San's parcel, 2735 Monroe, without the signature and approval of the first mortgage holder is invalid as a matter of law because Mama San's bargained away their right to make such a conveyance. They did it in exchange for a mortgage, a loan of almost, I think it was almost $500,000. So the specific language of the Mama San's mortgage says, and I'm going to read it because it's really important here. It says, neither the property nor any part thereof or interest therein shall be sold, conveyed, disposed of, alienated, hypothecated, leased, assigned, pledged, mortgaged, further encumbered, or otherwise transferred, nor mortgager shall be divested of its title to the property or any interest therein in any manner or way, whether voluntary or involuntary, in each case without the prior written consent of mortgagee, being first obtained, which consent may be withheld in mortgagee's sole discretion. So in this case, Monroe Assistance Fund is the mortgagee. They're the ones who gave the loan, and Mama San's is the mortgagor. They're the ones who mortgaged the property. It's undisputed that the developer has not provided the town with Monroe Assistance Fund's consent, and therefore the cross-access easement of the AMP is invalid under the plain language of the mortgage. Additionally, in response to demands we made during litigation, which are called notices to admit, the developer failed to deny the allegation that the cross-access easement did not include the consent of Monroe Assistance Fund. So there's no dispute that this wasn't provided. So to state it another way, when Mama San's mortgaged when Mama San's mortgaged 2735 Monroe Avenue, they bargained away their right to grant the easement without the mortgagee's prior written consent. That restriction was recorded, so it runs with the land, is enforceable, and was in the chain of title. So the town also had notice of it because it was recorded in the clerk's office. The developer's purported easement over that property is ineffective because it was only signed by Mama Sans, not by Monroe Assistance Fund. And so they plainly didn't have the legal authority to grant the easement. So going back to one of the board members' questions earlier, in order to transfer a property right, you need to own the property right that you're transferring, and you need to have the authority to transfer it. This mortgage undermined their authority to transfer their property interests because it said they can't do it without the prior written consent. So that's why the easement is invalid here. If the town illegally allows the developer to construct the project without ensuring that these easements are valid, it's taking a huge risk that the easements will be invalidated, thereby causing the access management plan to fail. And they're also violating the law because they need, according to the town's own approval, the easements required to construct and implement the AMP. So to say a little bit more about the risks, if the town goes forward without proper easements, it's exposing itself to two risks. One is failure to comply with the terms of the mortgage means that foreclosure will cut off after acquired cross-access easement rights. Mr. Sakin referenced that in when discussing his appeal. It also means that Mama Sans could, with the mortgagee's consent, sell the property or grant a conflicting interest to someone else. And if they had the the Monroe Assistance Fund's consent, then under the mortgage, that person would have a superior property right to the developers because they were granted the property right by someone who had authority to make the conveyance. And they had the authority to make the conveyance because they received the approval. So if that happened, again, you'd end up with the AMP failing. And if the AMP fails, this project becomes the traffic nightmare that everyone thought it was going to be from the beginning. The building inspector, Mr. Boehner, submitted a letter demonstrating that he disagrees with our interpretation. In his submission, Mr. Boehner argues that the easement is still valid, even though it's not disputed that the easements do not contain the first mortgage holder's consent. Ironically, though, he does not dispute that the underlying fact that he didn't obtain the mortgage. Instead, Mr. Boehner merely argues that those facts do not affect the validity of the easement. He argues that the unsatisfied mortgage condition merely renders the cross-access easements voidable rather than void. That's just completely wrong because he ignores the fact that by entering into the agreement, Mama Sans bargained away its power to unilaterally convey such an easement without the mortgage holder's prior written consent. The facts are important because they affect whether the easement was created at all. An affected easement cannot be made if the person making the easement doesn't own the land or doesn't have the power to create the easement. The Mama Sans mortgage, therefore, affects whether this mortgage deprived Mama Sans of the power to create the easement in the first place. That's why the Mama Sans mortgage prevented the developer from entering into valid cross-access easements, and therefore the developer has not satisfied the requirement that he obtain those easements prior to issuance of the building permit, which is why the building permit must be set aside. The developer's letter in opposition to our appeal advances a similar argument. The developer argues that there is no general requirement under the law that the holder of any mortgage consent in order to render the easement enforceable. The developer is wrong because he's mischaracterizing the issue. The question is not in a vacuum whether someone who owns property can create an easement over it. The question is whether when someone has intentionally and knowingly bargained away in writing their right to create an encumbrance of their property, in exchange for $480 or $480,000, something, an enormous quantity of money, if they bargain away their power to convey an interest in real property, then can they still convey it? And the obvious answer is no. Accordingly, because Mama Sans didn't have the authority to grant the easement, did not have the authority to grant the easement, it is invalid. And the town knew that Mama Sans didn't have the authority because the mortgage is in the chain of title and because they had a letter from the person who made the loan. Mr. Boehner also argues on this issue that the town has no role in determining the validity of the cross-access easement because he alleges it's a private agreement. He's wrong on that too. The town board's amenity agreement and incentive zoning approval expressly require the developer to submit to the town all cross-access and other easements necessary to implement the AMP, and therefore empower the town to review and approve such easements. The further conditions of approval, part of the incentive zoning resolution, likewise requires the developer to provide and file access rights for cross-access and cross-parking easements before a building permit may be issued. These approvals by the town board unequivocally give the town the responsibility to determine whether the easements are valid and whether they provide access rights for cross-access and cross-parking prior to issuing a building permit. Additionally, Mr. Boehner's argument that the town has no role in evaluating the cross-access easements and whether they're adequate in order to construct and operate the AMP is contradicted by his own actions and those of the town's employees. For example, the town attorney and building inspector records produced by the town reveal that they reviewed and evaluated the sufficiency of other private agreements related to this project, including private agreements related to cross-access. The records include emails between the developer, the town attorney, Mr. Gordon, and even Mr. Boehner himself, discussing the sufficiency of cross-access easements between private parties, including the developer and owners of the AMP properties. This completely contradicts the town's position that it has no role in evaluating private agreements. To the contrary, these emails, which were produced by the town only pursuant to that court order and were labeled by the town as Bates number 9869, which is different from the Bates numbers assigned to the ZBA record. I'm sorry, that's confusing. So the emails that the town produced show that the town attorney and Mr. Boehner believed that the town had the power to consider the private agreements affecting the developer's ability to construct and operate the AMP, and that they in fact did so with respect to the cross-access easements in this case, the very one which they're now saying they can't even consider because it's a private agreement. It would therefore be unfair for the town to adopt the exact opposite position now. Indeed, it would be the definition of arbitrary and capricious for the town to reach a different legal determination as to its ability to consider the sufficiency of cross-access easements when on the same facts it reached the opposite conclusion earlier. Accordingly, Boehner had the power and responsibility to examine the Mama Sans mortgage to determine whether it deprived Mama Sans of the power to grant the cross-access easements for the AMP. Accordingly, he should have considered whether the Mama Sans mortgage and the failure to obtain Monroe Assistance Fund's consent affects the validity of the cross-access easements, including the one over 2735 Monroe. His failure to do so and his failure to determine that the Mama Sans mortgage requires the first mortgage holder's consent, which was not given, renders the building permit invalid and requires that it be annulled. With respect to the second issue regarding certification of the site plans, the town code, as part of the site plan review process, imposes a building inspector certification requirement. Essentially, that's the opportunity for someone in the town to go through the plans and determine whether they comply with the zoning code. Essentially, the building inspector must review the plans and determine whether they comply or not. Town Code section 217-12A3 is where this requirement is found. It says that prior to issuance of a final site plan approval, and obviously therefore also prior to issuance of a building permit, the building inspector must certify on each site plan or amendment whether or not the plan meets the requirements of all comprehensive development regulation provisions. The failure to do so renders the plan and any building permit issued in reliance on that invalid. So here, there's no question that the building inspector failed to make a certification, the building inspector certification, prior to issuance of the final approved site plan or prior to the final approved building permit. That fact alone should be sufficient to annul the building permit. I have not heard the town dispute the fact that Mr. Boehner did not make such written certification prior to issuance of the building permit. Instead, it seems that Mr. Boehner argues that such certification is not required. And that's just wrong. It also contradicts the plain language of the town code, which says that the certification is required as part of the site plan review process. And therefore, these approvals cannot be granted without such certification. Mr. Boehner's letter also alleges that prior to issuance of the building permit, he confirmed the requirements of the comprehensive development regulations were met. Respectfully, he didn't do that in writing. And if, we can't decipher what's inside his head. For these approvals, they have to be written down, and the certification is important enough for the town to put in the town code. It's important enough for him to follow the letter of the law. Mr. Boehner's letter does not allege that he certified that such requirements had been met, only that he confirmed them, whatever that's supposed to mean. He also doesn't attach a copy of such alleged confirmation because, again, it didn't happen in writing. Instead, he's arguing that someone other than the building inspector, in this case, the town engineer and commissioner of public works, determined that the site plan complied with comprehensive development regulations. Boehner's letter also alleges that the commissioner of public works signed the utility page of the site plan, and he's arguing that that constitutes the certification required by the town code. That's just wrong. The site plan includes no certification whatsoever, and it appears that Mr. Boehner is conflating a simple signature by the Commissioner of Public Works with a certification, and those things are different. The signature of the town engineer or the Commissioner of Public Works is not the same as a certification. And the signature of the town engineer does not, or the Commissioner of Public Works does not satisfy the unequivocal town code requirement that the building inspector be the one to make the certification on the site plans. It appears that Mr. Boehner now asks the ZBA to ignore the plain language of the town code by trying to convince you, the ZBA, that the building inspector certification requirement can be satisfied by an unsworn signature rather than a certification of any town employee rather than the building inspector on a single page rather than on each page or amendment of the site plan. Mr. Boehner's interpretation, with all due respect, betrays the plain language of the town code and must be rejected. Mr. Boehner also tries to explain away the town's non-compliance with the building inspector certification requirement by essentially arguing that the ZBA should ignore the plain language of the code because, well, that's just not the way the town operates in practice. He essentially admits that he is violating the town code for his or potentially the town's convenience. And while it may be the case that the town does not strictly follow its own town code or the building inspector certification requirement, that does not make it right and does not make it legal, nor does it obviate the town of its duty to comply with the law. Mr. Boehner apparently concedes, though, that he did not certify on each page or amendment of the site plan whether it complied with the zoning code. Again, this is sufficient to annul the building permit. Accordingly, there's no doubt that the building inspector certification requirement was not completed, and therefore we ask the town to annul the building permit. Additionally, I'd like to add that the reason that this certification was not made is because it could not have truthfully been made. It would have been really easy for them to make the certification, but they couldn't, and they didn't want to open up avenues for appeal to the ZBA because they're hoping that everything will be the same as what happened for the town board. Moving on to my third issue regarding the failure to obtain all required state and local approvals. I mentioned before that condition 41 of the site plan approval from the planning board required that the developer obtain all state and county, all state and local approvals. In our supplemental affirmation, we identified several categories of approvals that the developer failed to obtain. The basis of that is that during the litigation for this project, BGR served notices to admit that the developer failed to obtain these approvals, and the developer failed to deny those things. So with notices to admit, if you fail to deny something within the time established by the notice, it is deemed admitted for purposes of the court proceeding. It also appears that the developer failed to deny the allegations in BGR's ZBA appeal. In response to a court order requiring the town to turn over all documents related to the developer's application for the building permit, the town failed to produce proof that the developer had obtained all required state and local approvals. Accordingly, it's clear from these sets of behaviors that the developer did not submit the proof that it had obtained all necessary state and local approvals prior to obtaining the building permit. I'd also like to address a local approval required under New York State Town Law, Section 64(2). That allows a town to convey or lease real property in the name of the town only if the town subjects such conveyance to a permissive referendum, a vote by the townspeople. In other words, a town may convey an interest in real property only if it first obtains local approval by subjecting such conveyance to a vote. The New York State Comptroller's Office has determined that the release or abandonment of an easement, just like this, is considered a conveyance that must be subject to a permissive referendum. Likewise, a New York State appellate court recently found that there was a question of fact as to whether this project would result in abandonment of the pedestrian public pathway easement, part of the Auburn Trail that goes across the property. And the court indicated that the town would need to subject the project approvals to a permissive referendum and state legislative approval under the public trust doctrine if the project would result in abandonment. So I guess you might be wondering, well, what's abandonment? As a matter of law, an easement may be abandoned through non-use, coupled with an indication of an intent to abandon the easement, such as permitting others to interfere with it and interfere with the use for which it was created. Accordingly, the crucial issue here is whether the project will interfere with the public's intended use of the existing trail easement in its current location. The project interferes with that use because it renders the easement's primary and incidental uses, i.e. use of the easement area as a pedestrian pathway in park-like conditions, less convenient. Now, the existing easement instrument expressly grants the town and the public the right to use the easement area for a perpetual pedestrian pathway. That's how we know what its purpose is. It's written down, plain English. The easement instrument also requires the town to, quote, construct, operate, maintain, repair, and replace a pedestrian pathway which the town shall require for public use across said land, end quote. It further requires that upon completion of any construction, installation, maintenance, or repair of any improvement, the grantee, i.e. the town, must restore the easement premises to a park-like condition. That's key, park-like condition. Thus, the purpose of the pedestrian easement instrument, the instrument that created the town's easement over this land at the project site, the purpose of it is to allow the public to use the easement as a public pedestrian pathway in park-like conditions in perpetuity. Here, the town is objectively indicating its intent to abandon the easement by granting approvals that allow the developer to interfere with the purpose for which the easement was created, by rendering the easement area less convenient for use as a public pathway in park-like conditions. That indication, coupled with non-use of the easement, constitutes abandonment and triggers the requirement that the abandonment be subject to a permissive referendum, i.e. local approval, under New York State Town Law 64-2. There's no doubt that the town has a property interest in the pedestrian pathway easement that runs across the rear of the Whole Foods Plaza. It is also undisputed that, as approved currently, the project will result in the construction of a 450-car parking lot, that some of the parking spaces and driving lanes will be placed directly on top of the existing pedestrian easement. Accordingly, when the project is fully constructed, anyone traversing the property using the easement that was supposed to be for the Auburn Trail will need to dodge cars, go around parked vehicles, and avoid the tractor-trailer turnaround at the rear of the Whole Foods building. This is obviously going to interfere with the use of the easement as a pedestrian trail, and will absolutely interfere with the requirement that those portions of the easement be restored to park-like conditions. Accordingly, the building permit illegally authorizes an abandonment of the existing pedestrian trail easement without requiring the town to obtain local approval through a permissive referendum, as required by Town Law 64, and as required by the planning board's requirement that they obtain these approvals before a building permit is issued. If the project will interfere with the public's use of the existing pedestrian trail easement in its current location, or render it in any way less convenient, then the project results in abandonment of the existing easement. And so the ZBA must annul the building permit for failure to obtain local approval. The other big approval that was not obtained is state legislative approval. This is under what's called the public trust doctrine. It's a legal doctrine that's existed for around 100 years in New York and is all over the place across the US. Different states have different versions of it, but they're pretty similar. The public trust doctrine prohibits local governments from alienating or substantially intruding upon parkland without the express approval of the New York State legislature. Essentially, that means if you're going to take property that is considered parkland, you cannot sell it or use it for non-park purposes without state legislative approval. In the BGR appeal in a related lawsuit, the Fourth Department found, as I mentioned earlier, a question of fact as to whether the project results in abandonment of the pedestrian pathway easement. Accordingly, just as in the permissive referendum analysis that I discussed previously relating to Town Law 64, just as in that analysis, if the project will substantially interfere with the pedestrian pathway easement, the easement that creates the Auburn Trail in the back of the Whole Foods Plaza property, if it substantially interferes with that easement by rendering it less convenient for the public to use it as a pedestrian pathway in park-like conditions, then the town's approval constitutes an abandonment and therefore is not valid without prior legislative approval, which has not been granted. Clearly, a 400-car parking lot, car drive lanes, and a tractor-trailer turnaround are incompatible with the trail being with the Auburn Trail being a pedestrian pathway, or with it being in park-like conditions. It is beyond any doubt that those surroundings, the parking spaces, the tractor-trailer turnaround, those surroundings clearly render the easement area less convenient as a public pathway, and the creation of a different easement in a new location doesn't affect the analysis. They still need state legislative approval if they're going to burden this easement. Accordingly, the site plan and building permit approvals, by authorizing a substantial interference with the pedestrian easement, which renders use of it less convenient, results in abandonment of the easement without state legislative approval in violation of the public trust doctrine and condition 41 of the site plan approval resolution. Thus, the building permit was illegally granted and must be annulled. The last issue that I'm going to address here relates to the phases issue, and I'll deal with it quickly because it was addressed pretty completely by Mr. Sakin. The FEIS, incentive zoning resolution, site plan approval, and seeker review all require the project to be constructed in a single build phase, as does the access management plan. At every stage of this project, the developer alleged the project would be built in a single build phase. And this is important because single phase construction has vastly different impacts than multi-phase construction. That comes straight from the Department of Environmental Conservation, seeker handbook. Indeed, the developer's own timeline confirmed that only a single construction phase was approved and that construction on all buildings would commence between January and March of this year and would be completed between July and August 30th of this year. That didn't happen. The building inspector violated the law and the town's own conditions of approval by granting approvals for this project to be built in multiple phases, i.e. by granting the building permits piecemeal, despite the requirement that they be built in a single phase. It's clear that this is only approval for one phase of the project because it's approval for the standalone Starbucks building, even though there are 5 buildings that are part of this project. And by project, I mean the Whole Foods Plaza as approved by the town board and planning board. The town hasn't issued any other building permits to the project, and there's no indication that any application for those other building permits are forthcoming. Therefore, the issuance of only one building permit for a 5-building plaza improperly authorizes multi-phase construction. And this whole discussion about, well, it's not phased, it's staged or sequenced, these are distinctions without a difference. This is clearly being done in multiple steps over the course of a greater period of time than was represented by the developer. The permit further authorizes the developer to relocate temporary fencing from the pedestrian easement, even though the construction of the project is not complete, and that would allow interference with the public's right to use the pedestrian easement that's part of the Auburn Trail in the rear of the plaza. By authorizing the developer to construct only part of the project and to remove these protections before to the Auburn Trail before construction is complete, the town's illegally approved multi-phase construction. Accordingly, the building permit was issued in violation of the town's own approvals and must be annulled. Thank you for allowing me an opportunity to present this appeal on behalf of Brighton Grassroots. Brighton Grassroots has many members strong throughout Brighton's community. And I want to take one moment to just respond to a comment that was made earlier. We are not, we have legitimate interests here that we're trying to protect the members of Brighton Grassroots. This isn't about Wegmans. This isn't about anyone else. This is about the people who live right in the vicinity of this project and how they'll be harmed by the shortcuts that the developer is trying to take. And unless there are any questions, I will rest on my papers and thank you for the time and attention today.
Okay, thank you, Jacob. Okay, board members, questions for Mr. Z?
This is Member Wright. I have a couple of questions. And some of them are echoing the same questions that we asked the attorney representing Save Monroe Ave. With respect to the cross-access easements, is your argument that the town should have done a title search, reviewed every mortgage document for any cross-access, any easement that's submitted as part of any application to confirm that it's not voidable in the future? Is that the argument, that when it reviews those access easements to confirm that they do in fact provide for an easement in the correct location and are signed ostensibly by the correct property owner, that they need to take those further steps to review every word of every mortgage, confirm that there's authority by the signatory on those documents, etc.?
So I think that the best way to think about this is to think about what someone needs in order to convey an interest in property. They need an ownership interest, and they need authority to convey. I think that, especially in this circumstance, where the town board expressly gave them authority to look at these easements, it's entirely reasonable to ask the town, when they're considering whether something is valid, to say, did you look at the chain of title to determine whether they own the property? Did you look at the chain of title to determine whether there's any encumbrance on the property that deprives them of authority to convey? Because if they don't do that, then they have no way of knowing whether the easement's valid. It's like if I were to go and try to sell your house, right? I don't own your house, and I have no authority to convey your house. So even if I wrote up something trying to convey it, it wouldn't be valid. Even if I recorded it, it wouldn't be valid.
Right, but if I tried to sell you my house that I owned, and I happened to have a private agreement with a third party where that third party said, you can't do this without my consent, vis-a-vis you and me, a recorded deed to my house would still be valid against me and against any further purchaser by you, because it would be recorded in record.
If
would you
had granted if you granted a mortgage to someone, and as a condition of the mortgage, so someone's giving you money, as a condition of getting that money, you say, I will give up my power to transfer an interest in my property without your consent. And then that mortgage containing that clause is recorded in the county clerk's office, then anyone who goes and pulls records related to that property, that mortgage will show up. And they will read that mortgage and they will see that you do not have the authority to make a conveyance without the lender's consent.
Let me just ask it this way then. If you run a title search on a property, you're purchasing a property and you run a title search, and the title company pulls out what's on record in the property, they don't automatically declare easements, at least in my experience, they don't automatically declare easements invalid by reading the language of a mortgage that may or not restrict a property owner that requires consent, and they may not have evidence of consent of that mortgage holder. They will exclude coverage for any easements given by the property owner because they're recorded, because on their face, they are enforceable against the property owner.
I think you may have a misunderstanding respectfully about the effect of recording. Just because something is recorded doesn't render it valid. I mean, there's the famous quote that a clerk's office has to record a ham sandwich if you tell them to. The determination of whether it's valid comes later. You can take all the things from the clerk's office, from the title search, and you evaluate them to determine whether there's any that are invalid.
Right, but an easement agreement executed by the property owner at the time that it was given, that is recorded, would be deemed valid by a title company. In my experience as a real estate attorney, I mean, would you disagree with that?
I don't think it would be deemed valid if there was a recorded mortgage in the chain of title that said that the owner of the property does not have the authority to convey the property without the mortgage, the lender's consent.
We're really conflating terms here. Let me try, I know where you're going. Let me try this. So if you look at that mortgage, which I've read, it has a default clause, right? And it sets up a whole bunch of different potential defaults, one of which is a conveyance of an interest not without the permission of the mortgagee. Okay, that's a default. Okay, and the mortgage also sets out a series of typical, Andrea would know, typical remedies. There's a section, remedies upon default. And there's no remedy there that says I can, get back from someone who you've sold there's no ability to claw back property that the owner, the mortgagor, has sold or transferred to other people. That remedy just isn't in there. The only remedy, as you pointed out, is the remedy to foreclose. And we don't use in real estate terms like valid. There is, the deed, it's not that the deed is valid. There are voidable deeds where you can go back and you can crawl back under certain circumstances. But this contractual relationship between the mortgagee and the mortgagor is governed by the mortgage. And this mortgage has very specific remedies for defaults. And this transfer would be a default. There's no question about that. Right, Andrea? You agree? That's a default under the mortgage.
Absolutely.
Right? It's a default under the mortgage, and the mortgage holder has the specific remedies set out in the mortgage. And there is not, I can assure you, I read it, one thing, and two, I've never seen it, and I'm sure Andrea hasn't either, some kind of clawback provision where I can get back from the person you sold some interest to, I can get it back. It's not there. If I bought this house for $1 million, if I bought Mama San's property for $1 million, okay, and I gave B. Walters $1 million, and I took a deed from her, the deed's gonna be valid. The mortgage holder can foreclose against my interest because that transfer is still subject to that mortgage, but I have a valid deed. The valid doesn't even count. I own it. And so this argument is, to me, it seems really, I don't know, you're gonna have to bolster my thought of valid deeds, and it just doesn't follow through.
Okay.
I don't know if you can
And I
respond
think
to that, but
All right.
the larger concern too is, whether or not a deed or an easement is voidable is an incredibly intricate process that we simply cannot require towns in New York to read every single word of every single recorded document to confirm that it's not potentially voidable, or it's not potentially a default under a mortgage, or someone doesn't have authority based from a third party to grant it. Towns have to be held to some sort of a reasonable standard of review. And I don't see how, even if your argument is correct, which I think, I'm not sure I agree with, but even if it was, I'm not sure you could hold the town to that kind of a review standard.
So the portion that I was citing from the mortgage was part of the covenants section of the mortgage, not the default section. And in the covenant section, they conveyed their power to grant any encumbrances of the property. And so even though they are the owners, they bargained away their right to do so without the approval of the first mortgage holder. So frankly, they just didn't have authority to make the conveyance in the first place. It's not a matter of whether something was forged or fraudulently induced. Those forgery versus fraudulent induction are the differences between void versus voidable. We don't even get there to the question of whether something is void or voidable if the person who created the instrument didn't have the authority to convey the property interest. So analytically, the authority to convey must come before.
Okay. All right. So we're getting off into a little bit of a debate here, but I think at this point, I would like to move on to the board members as it relates to any other questions for Mr. Zoglin here, so we can keep this proceeding moving. Is there anyone on the board that would like to speak and ask any other questions?
Yeah, thanks, Dennis. This is Jeannie again. I wanted to repeat the questions that I had for the earlier opposition to the issuance of the building permit. since that's the matter at hand here. And I know that it was mentioned previously that part of the concern was increase in traffic. So my first question was, how will the issuance of the building permit for Starbucks increase traffic accidents?
Thank you. Jeannie, I'm sorry, I don't know your last name, and I want to address you respectfully.
Oh, that's fine. It's Dale, D-A-L-E.
D-A-L-E, thank you. So I saw that you asked the same question of Aaron earlier tonight, and I appreciate that because it gives me an opportunity to refocus this on the AMP. So your question is, how will the issuance of the building permit increase traffic? How does it impact people? It impacts people because in a couple ways. One is by doing this without the cross-access easements, they're setting the AMP up to fail. And if the AMP fails, traffic is not going to be, the adverse traffic impacts that were identified during seeker review will not be mitigated because the AMP is the primary mitigation for the adverse traffic impacts. And that's going to harm the people along Monroe, but more so BGR members because of their close proximity.
So speculative regarding the AMP.
No, it's not speculative. That's a finding, a legislative, I mean, essentially it's a finding of the town board and of the planning board. That was part of their seeker review. I mean,
I was saying for your comments about setting it up to fail.
I mean, no, the town has explained that it's essentially, the AMP is a stool that's composed of these three easements. And if you take away any of the three easements, the stool tumbles over. Because if you don't have the easements, then people from one parcel can't go to the other parcel, and then the other parcel to the light. So it's not speculative. I mean, they don't have the legal right to go from one parcel to the traffic light. And that's the entire way that they're dealing with the traffic problem that traffic engineers and the developer all determined were going to result if they didn't create an access management plan.
Great.
Okay. So another one of my questions, because we're again, talking about concerns for the neighbors and the restaurants and such, is given the nature of the surrounding property uses, so hotels and restaurants we're talking about here, how would the issuance of the building permit for Starbucks detrimentally or noticeably decrease the ability of customers or the appellants for their safety and convenient access to the businesses and homes?
So I'm sorry, let me get my light. There we go. So the first answer is really simple. I mean, the building permit, by proceeding without all of the cross-access easements for the AMP, are going to result in adverse traffic. And adverse traffic is the type of harm that courts recognize as being sufficient to establish standing, especially for adjacent property owners, people that live, especially our clients live very, very close to this proposed development. The other issue where they'll be negatively affected is by the Auburn Trail. I mean, they're not gonna have access in the same way to the pedestrian easement that is part of the Auburn Trail going behind the Whole Foods property. They have a legal right under the easement to use that as a pedestrian pathway in perpetuity in park-like conditions. And the deprivation of that legal right is an injury. We also have legal rights in seeing that the zoning code is enforced. And courts have recognized the right to see laws enforced as being a valid right sufficient for standing as well.
Thank you.
Thank you.
Okay. Okay, board members, go ahead, Andrew.
Yeah, sure. Just, you were obviously, I'm sure, listening when Mr. Daniele got up and spoke to kind of provide his argument with respect to timing on this project. One of obviously the bigger arguments is that this is a phased construction, that because they got one permit permit for the site work and the Starbucks without also pulling permits for the rest of the building, that evidence is that this is the first phase of a multi-phase construction. He testified as part of this hearing that they're doing the site work now. That should take 4 to 6 months. They anticipate 90 days for construction of the additional buildings, and they anticipate being completed by summer of 2021. Would you suggest that if they met the timeline, that that's still phased construction?
I would say, since they're pulling these permits one at a time piecemeal, and that they've not shown any indication that they're going to apply for or pull or are prepared to do that for the other permits, that the facts as they currently exist establish that it's phased. They've already started phasing it. They're doing 1 out of 5, 20% of the buildings right now. I mean, call it a phase, call it a stage. It's a distinction without a difference.
Right, but even in their initial plan for this, they were not going to do all permits at one time.
They were going to do
right?
them within,
I mean,
I think, 2 or 3 months.
Yeah. So, but they would have at least, is it 6 months in Brighton to construct once a building is permitted, or is it a full year? Rick, do you know? Oh, well, obviously you know, sorry.
That's fine.
Yes, it's a full year. Andrea.
Full year. So,
And then
so
they
their
can request, and
construction,
they can
you know,
request extensions also.
yeah. So even if they pulled all of their permits at the exact same time, they could still have spread out construction over the time period that they're roughly talking about, at least testifying tonight. Is that fair to say or no?
I'm sorry, you're asking me or Rick?
Well, I guess, I mean, I'd like to know kind of the applicant's, you know, theory on it, that if they pulled all of their permits, they could have still done one building, done some site work, waited 6 months, done a little bit more, and still been in full compliance with the process. Is that accurate?
I think if they had pulled the permits in the, according to the order and timeline approved by the planning board, then there would be less of a concern about phasing. But that's simply not what's happened. They're pulling them one at a time without any indication that they're prepared to do the next one. And by the way, there's an agreement that's been signed off on by the court where if they are going to pull a building permit, they have to provide notice to the parties, and they've not provided notice about intent to pull any other building permits as far as I'm aware. So that just, it further indicates that they're just not in a position to do this right now, and that's why they're doing this in phases, you know, one at a time.
And then one more, just, and this, I may have missed it. Obviously, as you can imagine, this was a very voluminous package for the planning board to review. Your arguments regarding the permissive referendum and the legislative approval, were they in your submissions, or is that an argument you're making through testimony only? I just wanted to make sure I was referencing the right parts of it.
You know, there have been so many submissions as part of this case. I would have to check which ones. But my recollection is that they were part of the supplemental submission.
Okay.
So I believe the supplemental affirmation is where it's located. But I would need to look through my records to know that for sure. So I don't want to be unpolite by looking through documents while we're on the meeting tonight. Unless you'd like me to, I can pull it up.
No.
Rick, did we get the supplemental filings before the meeting?
That was
Those
submitted
ones that are coming in.
well past the cutoff date.
Okay.
So there's no way you guys would have had time to review it.
Okay, I just wanted to make sure we weren't supposed to be reading something else as well as part
No,
of this.
No.
And then, it may have been you again, it may have been another townspeople, but some safety concerns were brought up last month. I asked the previous attorney for Sabanmore Avenue as well. I know that there was a comment about construction fencing and a safety concern. Kind of wanted to get some color on that, if that is an objection, if there is legitimate safety concerns about whether or not pedestrian easements are obstructed throughout that property.
Well, one of the biggest safety concerns is, and this was mentioned, I believe, at the last meeting, was the fencing being taken down. And particularly, there's another safety concern about the Auburn Trail easement because of the place that it's located. The existing Auburn Trail easement, if the project were fully developed, would be right in the middle of that parking lot and the turnaround aisles for the tractor trailers and the drive lanes. So in addition to the construction fencing coming down, there's the safety hazards associated with anyone lawfully using the pedestrian easement as a pathway in park-like conditions. So those are certainly safety concerns, and the concerns about the Auburn Trail and the easement are going to persist even after this project, if it's ultimately constructed, goes into operation.
Is that specific to issuance of the building permit in general, or is that specific to the approval of the project? The safety concerns with respect to the Auburn Trail?
I didn't raise the safety concerns with respect to the Auburn Trail in relation to my appeal. I raised them in response to your question.
No, I appreciate that. I was just trying to make sure I wasn't conflating the issues there.
Okay. Yeah, I don't want to go into something that I haven't briefed in my papers. But those are my opinions on the safety issues that you've asked about.
Okay.
Are there safety issues with respect to the issuance of the permit that aren't related to what was approved for the project as a whole? For instance, any safety concerns with, aside from environmental, with actually pedestrian or passersby safety concerns with issuing a building permit of only a portion of the property at one time instead of the whole project, things like that?
I think the biggest safety concern that is specific to this is, okay, so if the Starbucks, let's say it's constructed and goes into operation, right? If the AMP is not in place at the time that the Starbucks goes into operation and use, then there's going to be safety concerns associated with that because of the increased traffic. And I think it's pretty common sense that where you have increased traffic, statistically, you will have increased accidents and safety concerns. The town board clearly recognized that when they made the AMP a mitigation measure for the traffic. So I would say that proceeding with the Starbucks without complying with the requirement to ensure that the AMP can be construction and put into use is a massive safety concern. And doing so in the face of the town's recognition of that concern, wow.
But I believe there is a condition within the incentive zoning that prior to the issuance of any C of O, that AMP has to be completed. So I don't think we will get into a traffic issue at that point.
Valid. Okay. All right. So let's move along with questions. Board members, Kathy, John, Judy, any other questions for Mr. Zoglin?
I have a few.
Okay, Kath, go ahead.
All right. Hey, thanks so much for being here and answering some questions. As you know, this was a lot of papers to go through. You mentioned tonight a couple of times about the trail and how it needed to be a pathway with park-like conditions. I guess I'm wondering what that means in light of what I have always thought of that part of the trail when I walk it is like, because when I have walked it, it's a parking lot, and it's always been a parking lot. and you kind of skirt behind what used to be the bowling alley, and you walk around, and you used to kind of go behind the Mario's tent and the employee parking lot and then go through. Is that park-like conditions that you're talking about that are being changed?
Hello, Ms. Schmidt, and thank you for your question. So the park-like conditions language and the other language I reference, that's not coming from my head. That's coming from the easement that was granted to the town that created the public pedestrian pathway that goes across the rear of the Whole Foods Plaza parcel. And it says that the town has, this duty to create and maintain the public pedestrian pathway. And it says that it needs to restore the pathway whenever it does anything to it to park-like conditions. Now, if your comment is that currently your impression of that location is not park-like, that would go to whether the terms of the easement have been complied with. Frankly, I have not been very pleased with how the town has treated this particular easement. It's part of what creates the Auburn Trail and gives you as the public the right to cross it. They've not been very good about maintaining it, and they've not been good about restoring it to park-like conditions. That doesn't mean they don't have a legal obligation to do so under the easement. And that's not just affecting the town's rights, it's affecting the public's rights.
And is it your understanding, though, that as part of this overall project, that they are going to improve that part of the trail?
Thank you for that question, because it's a really nitpicky issue. They are not going to improve that portion of the trail. They're going to create a new and different trail. And that does not satisfy, there's no exception to the public trust doctrine. You can't say, oh, that trail's better, so they don't need to comply. They don't need state legislative approval. That's just not the law. They're going to create a different trail in a different location using a different easement. But they are not going to maintain the existing easement in the existing location in park-like conditions as a pedestrian pathway in perpetuity. And therefore, the law of the state of New York for over 100 years requires them to get state legislative approval. If it's no big deal, go to the state legislature.
And getting back to the building permit, can you explain how the building permit for Starbucks interferes with the use and enjoyment of the Auburn Trail?
So your question is how the building permit for the Starbucks impacts the Auburn Trail? Is that your question?
Yeah, how does it interfere with it?
So the approval from the planning board, condition 41, required that all of these approvals be obtained, state and local approvals be obtained prior to issuance of any building permit. So it is a condition of site plan approval that they obtain these approvals, and the project as approved, of which this is based on, allows the town to interfere with the Auburn Trail easement. And that's why that's how it's tied into the Starbucks building permit.
So it's the project itself, not exactly the Starbucks permit. Is that correct?
Well, it is the Starbucks permit because the permit cannot be issued without the approval. Right? It's a condition of site plan approval before a building permit may be issued. For any of the buildings, they need these approvals. So because the building is part of the project that was approved, they need the approval from the from the state legislature.
Okay, and one final question, and I'm still kind of circling back, trying to understand your client's injury and how it's different from the kind of harm to the public. I get that you're saying that there's adverse traffic, that the trail may not be as accessible, but I'm not seeing how that's different from the average. If that's true, how that's different from the average Brighton resident.
Proximity. I mean, if you're right next to a big project that's going to have massive project traffic impacts, you're going to be driving past it every single day. You know, the people on the other side of town, maybe they drive past, maybe they don't. But the case law on this couldn't be clearer. People that are that close to a project, there's an inference that they're going to be affected by it. I think that the traffic studies conducted by the town board and the applicant's contractor, you know, these things show that there's going to be massive traffic impacts. It's not at all a stretch to say that those impacts are going to affect people that are close by. Additionally, our clients, they regularly use the Auburn Trail in its current location, the pedestrian pathway. And so if there's any interference with that as a result of this project, that will affect them. It will deprive them of a recreational and aesthetic use to which they have regularly exercised their rights. And lastly, their right to see the laws enforced. In this specific instance, seeing the laws enforced affects them more than people on the other side of town, again, because of how close this project is.
So it's not your argument that somehow their property values are lower?
You know, that may be true, but you know, I think I don't need to get that far to establish standing. You know, I think that certainly people have argued that it will lower property values. That may be the case, but the traffic impacts, the impacts to their aesthetic and recreational resources, the impacts to the Auburn Trail and their interest in seeing the laws followed are sufficient injuries as a matter of law to establish standing. And I honestly don't even think the developer would dispute the standing issue, or the town, to be honest. Maybe they would, but I'd be very surprised if they went that far.
Thank you.
Thank you, Ms. Schmidt.
Okay, all right. So board members, any more questions, please? Okay. All right. So at this point then,
Yes, can I ask a couple questions?
yes, David.
Yeah, Jacob, isn't it true that there's pending that the public trust act, the requirement for the public trust doctrine, and the abandonment and all of those other requirements are the requirements and the necessity for those things are being litigated at this time, correct?
We've asserted claims under the public trust doctrine and permissive referendum, Town Law 64-2 in our lawsuits.
Right, and they're before Judge Ark now. I'm not really all that familiar with it, but aren't they?
Yeah, those claims are alive and well, and Judge Ark.
There has been. It's true that there has been no real determination that those things are required at this time.
The fourth department, although not settling
In this particular instance, right? But go on.
The fourth department said that there was an issue of fact that precluded summary judgment against our public trust claim. So there was a question of fact as to whether there was an abandonment. Okay, so that means that the appellate division analytically determined first that there's a property interest, likely also determined that it was parkland, although I don't want to speak for them, but analytically that's my understanding. And therefore they said, well, we're reaching the question of whether it was abandoned. And if it was abandoned, then the town must obtain state legislative approval under the public trust doctrine and subject the approvals to a permissive referendum under Town Law 64. So the issue really is whether an abandonment occurred, and if it occurred, then those requirements must be satisfied as a condition.
So you would expect Ramsey to review all that and make those determinations as part of the issuing this building permit?
The ZBA is now the one in the position to, and
well, even us, even if we're looking at it de novo, Jacob, I mean, would you want us to substitute our judgment for the judgment of the pending before the court?
The court hasn't made a judgment on those facts. Remember?
That's what I'm saying. There's no determination made, but it looks like you're kind of requesting us to make that determination prior to that's my point. I mean, it seems.
Well, the zoning board is, in a position to look at uses. Do they think that a 450 car parking lot, trailer tractor turnarounds, and drive lanes are consistent with a public pedestrian pathway in park-like conditions? I don't think that's a particularly difficult ask. If they think that those are in conflict, then they should ask, tell the town to go get the approvals that are required.
And then just one more last question. So you cite in your papers Town Code 217-12A3 that requires the building inspector prior to issuance of site plan approval to certify that each site plan and amendment thereof meets the requirements of the town code block. But you put in there the parenthetical phrase prior to the issuance of the final site plan approval, and parenthetically, and therefore also prior to the issuance of a building permit. That's not in the statute. That's not in that ordinance, correct?
I'm sorry. Can you repeat that?
Yeah. It says that you assert that Town Code 217 requires the building inspector prior to issuance of final site plan approval. And then you have a parenthetical phrase, and therefore also prior to issuance of a building permit to certify each site plan amendment. Is there a requirement specifically in any of the ordinances that says that the building inspector has to certify that the requirements of the comprehensive plan have been met prior to the issuance of a building permit, or just prior to the issuance of a site plan approval?
Again, analytically, this requirement is part of the site plan review and approval process. So you can't even issue a building permit until you've gone through that process. And you can't issue a site plan until you've gone through that process. So analytically, you must get this building inspector certification prior to issuance of a building permit.
So you're challenging the site plan. You're basically saying the site plan wasn't done correctly because it as part of this building permit application?
Pardon me? The site plan, so it's interesting, he didn't do this when the site plan approval was pending either. And when we went to Mr. Boehner and asked for an interpretation of the code, which is essentially asking him to certify that the code had been met, he didn't respond. And then we filed a ZBA appeal asking the ZBA to consider issues. And the ZBA said that we didn't have jurisdiction because, that the ZBA didn't have jurisdiction because Boehner didn't make any decision. So, I mean, we're being told we can't appeal it either way because Boehner refused to make the decision at the site plan approval. We asked him to make a determination. We applied for the interpretation, and then we appealed it to the ZBA, and the appeal was rejected. So, if the ZBA at that time took the position that we couldn't address the compliance with the zoning code issues at that time, and now this suggestion, Mr. Dollinger, that we can't raise the zoning code compliance now, begs the question, well, when does the town want us to raise the non-compliance with the zoning code?
Thank you.
Is there a specific harm? I mean, are you arguing that if he I know that you're papers note that he couldn't have certified it because there were certain zoning violations. Town has responded that as part of the incentive zoning approval, there were no violations. It was in full compliance. So are you arguing that it wasn't in compliance or just that it was a failed signature? And if it's a failed signature, what's the necessary harm and remedy for that? Particularly as if I think somebody alleged that most of these aren't signed. So that would beg the question, how many permits now need to be revoked for kind of a failure to follow a procedural step?
I would love to get into the merits of what we think was not complied with, but there's not been a certification from the building inspector that we can appeal. And once he appeals it, once he makes a certification, it will be a decision that we can appeal to the ZBA. Unfortunately, he's never made a certification in violation of the zoning code. The town code. And so we're not in a position to appeal because there's not been a decision by Mr. Boehner because he's abdicated his duty to review and certify whether or not the plans comply with the zoning code.
So the harm is a lack of an ability to appeal it then?
I mean, the harm is it violates the law. It's expressly required. There's no ambiguity whatsoever.
All right.
I meant the harm to the applicant.
In addition to the traffic harms and the failure to follow the law, I mean, because failure to follow the law is a harm, even if it's a procedural thing. The harms resulting from the project are the ones that give us standing.
Okay. All right. Are we set? Andrew? Okay, thanks. Okay, all right. So at this point then, let's see who in the audience would like to speak regarding this application. And what do we got? Ramsey?
Yeah.
Please proceed.
Once again, good evening. I'm Ramsey Boehner. I'm the town planner. In attendance with me tonight are Mike Guyon, Commissioner of Public Works, John Mancuso of the law firm of Weaver, Mancuso, and Brightman. I would like to thank the chairperson and the board for allowing me the opportunity to submit my letter to the board in opposition to application 9A-0420, submitted by Save Monroe, and application 10A-0220, submitted by Brighton Grassroots, and for the ability to be able to answer any questions that the board may have. I would like to thank your board for all your efforts on this matter and for the matters that are before you. The letter that I submitted was prepared with the assistance of John Mancuso as special counsel with respect to both the Save Monroe appeal and the Brighton Grassroots appeals. For the reasons discussed in the letter, the town issued the building permit in accordance with the applicable laws, regulations, including the requirements of the town's comprehensive development regulations and all approvals issued by the town board of the town of Brighton and the town planning board. And accordingly, the appeals should be denied and the issuance of the permit upheld. I believe the letter speaks for itself, so I will not be presenting my response to the appeals in great detail. I would like to point out that we prepared a spreadsheet that summarizes our responses to the allegations presented in both appeals, which I think you might find helpful. Before I ask Mr. Mancuso to speak, I would like to say, as the planner for Brighton for over 30 years, I've dedicated myself as an employee of the town of Brighton to high ethical standards and to protect the safety, general welfare of our community. In light of the tendency on part of some people regarding this project to make false allegations against the town and discredit town employees, I understood that every effort needed to be made to assure the highest caliber of administration and review was conducted prior to the issuance of the building permit for the construction of the plaza. It is important for me to stress that if all applicable laws, regulations, and requirements of the comprehensive development regulations and conditions of the incentive zoning and planning approval were not met, I would not have issued that permit. There's no way I would have done it. Not for this project or any other project. But given the controversy of this project, believe me, we are dotting our I's and crossing our T's. I believe you will find, after you review my letter, that a thorough, comprehensive, and complete review was undertaken by the town prior to the town issuing the building permit for the project. The town issued the building permit in accordance with the applicable law and regulations, including the requirements of the comprehensive development regulations, the incentive zoning resolution, and the site plan approval. Also, given that 3 separate additional submissions have been made for this application, I'd like to request the opportunity to review those new submissions and any addition submissions that are made in the future and be granted the right to respond as part of the record to any allegations made in those submissions. I now would like to ask that Mr. Mancuso be given an opportunity to address the board regarding this matter. And once again, I would like to thank you for your effort and consideration, and I will make myself available for any questions that the board may have.
Okay. Thank you, Ramsey.
Thank you.
Good evening, members of the board. Before I begin, just to echo Mr. Boehner's last statement, to the extent that the board has any questions of Mr. Boehner, certainly I would yield the floor to the board at this point. Otherwise, I'm happy to provide my brief, hopefully brief recitation of the arguments in support of Mr. Boehner's issuance of the building permit. So with that, I'll just stop for 1 second to see if the board would like to ask questions first.
I think we should go ahead, John, and proceed.
Thank you. As Mr. Boehner indicated, my name is John Mancuso. I'm special counsel to Mr. Boehner with respect to the defense of his issuance of the building permit. To echo Mr. Boehner's statements for a moment, both of the appellants in this matter are wrongfully attacking the town and Mr. Boehner with respect to the issuance of the permit, with respect to the project generally. And the idea that Mr. Boehner and town and the planning department have buried their collective hands in the sand or disregarded the laws of the town and of the state of New York with respect to this project is baseless, and we submit not supported by the law or the record in this case. Mr. Boehner and his department, as the record reflects, thoroughly reviewed this project prior to the issuance of the building permit that's before this board. Let's not forget that the site plan approval for this project was issued in September of 2018, and we sit here today in October of 2020 reviewing the issuance of the building permit. For 2 years almost, Mr. Boehner and the department evaluated project submissions. They went through 10,000 pages of documents requesting additional information, submissions by the developer and others to ensure that this project, that the issuance of this building permit met every single requirement of the comprehensive development regulations, every requirement, every condition of the town's approvals, the incentive zoning approval, the conditions of site plan approval, and the amenity agreement. And only after that exhaustive review by the town did a building permit get issued for the construction of the Starbucks and the site development work for the project. Now, to briefly respond to some of the arguments that have been made this evening, and again, I would defer to Mr. Boehner's submission because it obviously details all of the responses to every argument, but to focus on a couple of issues that have been addressed this evening. The first of which is this issue of the cross-access easements. We've already heard multiple people speak with respect to this. I would concur in the recitations and arguments, statements made by Mr. Dollinger, by Mr. Rosenbaum. This issue of the cross-access easement validity is simply unsupported by New York law governing real property. These easements, and there's been no accusation to the contrary, nor could there be, that these easements are not executed appropriately by someone with authority being the property owners, no dispute that they don't own the property that signed these easements, and conveyed a valid easement interest that the developer is utilizing for a basis of supporting the access management plan improvements. They are valid easements, and whether or not there is some future circumstance that may or may not arise with respect to those easements, whether it's a foreclosure or otherwise, is complete speculation. We simply do not know what will happen if there is a foreclosure, if there is not a foreclosure, if perhaps there is a foreclosure, but they don't decide to foreclose those easements. That is certainly all plausible, but all speculation. They are valid interests until determined otherwise. I agree with the board member, Ms. Wright, in terms of the burden and issues associated with effectively having town and municipalities being abstractors and reviewing chains of title in every single word that is contained in a mortgage or any other instrument. Simply not supported by applicable law. The conditions of those mortgages are private contractual agreements. The notion and accusation that Mr. Boehner and the town disregarded review of those easements is not correct. And is not the arguments that are set forth in the papers. The arguments are that the mortgages themselves are private contractual agreements. Obviously, the town received and reviewed those easements prior to deciding that as a substantive matter, they were sufficient to carry out the implementation of the access management plan improvements. And there is no argument or suggestion, substantively speaking, that there is any problem with those easements as prepared, as filed in the Monroe County Clerk's Office. The only issue seems to be one of an assumption, a mistaken assumption that they are void from their inception, and that's simply not legally supportable. And so for that reason, that basis of objection on the cross-access easement issue should be rejected. Turning to the issue of the multi-phase construction argument that both Save Monroe Avenue and Brighton Grassroots have raised. There was a lot of discussion about the characterization or mischaracterization, as the case may be, of the notion that this project is being constructed in multiple phases in violation of town approvals. What is conveniently disregarded completely from both arguments is the fact that the town's review and the issuance of the building permit is dealing with a completely separate issue from that of seeker phasing, as that is defined under seeker law that was reviewed by the town board and subsequently rendered in the finding statement they issued. What we're really talking about and what the building permit is speaking to is construction sequencing. That is the sequence by which a developer is going to move earth and construct the project site. Now, there is a sequencing plan that the town reviewed and that the town required of the developer to prepare in order to ensure that any disturbance of the project site, the regulation of stormwater management, controlling of erosion, that these things were addressed as part of a sequencing plan, so that instead of effectively allowing the developer to go out and move earth with some complete completely unfettered discretion, that there was a particular plan that the town reviewed and approved to ensure that in sequence, albeit one phase of construction, but in sequences within the project site itself, that they moved from one sequence to another to ensure that everything was protected from an environmental standpoint to regulate stormwater and control erosion. And that is supported by a litany of guidance from the Department of Environmental Conservation and is frankly standard construction protocol for a project of this type. And certainly I would turn it over to Mr. Boehner or Mr. Guyon to the extent they wish to supplement or add to what I've indicated. But that's what we're talking about. That's what the building permit has been issued and is why there is a sequencing plan in place. But it is not inconsistent in any way, shape, or form with any approval or the seeker review that was undertaken by the town board in connection with the project. Nothing prohibits the town from imposing these requirements, which are best practices for stormwater management and soil erosion. To move on to some of the other issues briefly, the issue of certification, to echo Mr. Dollinger's question, it's contained in the site plan components of the town code. There's nothing in the components of the building permit section that require the building inspector to certify a site plan. Those issues are in front of the court currently. They have not been adjudicated. Their remedy is to deal with it in the challenge to the planning board site plan approval. But as it relates to the issuance of the building permit, which is before this board currently, there is no requirement in the town code for a certification on site plan. That's a site plan requirement. Additionally, the form over substance and argument that effectively the process that was followed by the town dating through several years in terms of reviewing substantive compliance with the comprehensive development regulations, and as explained in the building inspector's submission, culminating in the sign off and approval by the Commissioner of Public Works with respect to the final plans that would lead to the issuance of the building permit, the argument proffered is without merit and should be disregarded. Ultimately, the Commissioner of Public Works under the town code can be deemed the building inspector. And also has appointed Mr. Boehner as a building inspector and many other people within his department to undertake certain roles on behalf of the Commissioner of Public Works to manage all things related to the zoning process in the town. And so the process followed here, substantively speaking, is that a thorough review was undertaken as detailed in the submission. And as part of the review by Mr. Boehner and the department, they are checking, as Mr. Boehner indicated, compliance with the comprehensive development regulations and every other aspect and condition of approval that's associated with this project. Until such time as they make that determination, and in the document it does reiterate that Mr. Boehner had in fact made that determination, there will not be a signature placed on those plans. And so Mr. Guyon's signature as the Commissioner of Public Works, in reliance upon all of the hard work that was undertaken by his department, including Mr. Boehner, affixes his signature to the plan to represent that the plans are compliant with the town's regulations and any and other applicable approvals in order to allow for the eventual issuance of the building permit. In the absence of that signature, Mr. Boehner would not sign a building permit or issue it. And so that signature, as is set forth on the plan, the utility plan, is the practice of the Public Works Department and the town, certifying that it meets the requirements of the comprehensive development regulations. And I think the question that was posed by Ms. Wright is an appropriate one in terms of understanding what are we really talking about, a signature on a page or substantive compliance. So, you know, with or without a signature, to which there is a signature, the real issue is whether there's compliance with the comprehensive development regulations. And the only arguments that have been made have all been refuted in the submission, in addition to some that haven't been raised, but the issues of compliance with use variances and the like are all without merit. As explained, this is an incentive zoning project. And so the town board has granted an incentive to give relief from those provisions of the code such that no variances are necessary. And so the project is compliant, substantively speaking, and the argument to suggest to the contrary that a certification has not been undertaken is not supported by the record. And so with that, I will reserve to the extent that the board has any additional questions of Mr. Boehner or Mr. Guyon and myself. I will turn it over back to the board and or Mr. Guyon or Mr. Boehner if they wish to add anything to this.
The only thing that I would add is that it is clear in the incentive zoning resolution anticipated multiple building permits being issued. And it was stating that with respect to the trail amenity, that the developer shall complete the construction of the trail within 365 calendar days, on which the town issues the first building permit for the project. And throughout those documents, it did reference and gave the idea that there were going to be multiple building permits issued for the construction of the buildings, and that the plaza itself would be built in a single phase.
Okay. All right. Now, did Mike Guyon want to say anything, or are we okay there?
Dennis, I think John covered it pretty well. I can, regarding the phasing project, we certainly require any project of this magnitude to develop a sequencing plan, here referenced as a phasing plan, to ensure that we minimize the amount of disturbance on the site It is required by the DEC. It allows us to best manage the erosion control and everything else on the site. So that's very, very common practice, and it's a practice we used here.
Okay, very good. Thank you. Okay, let's move on to any other persons who would like to speak regarding application 10A0220.
I think Judy wants to speak.
I'm sorry?
I think Judy was trying to speak.
Yeah. Okay.
What do you need, Judy? Judy, you got to unmute your mic. Okay,
All right.
go ahead.
Okay. In point number 4, where you talk about the cross-access easements are sufficient, is that a normal word, or is there anything stronger that can be more reassuring than just saying sufficient? I mean, to me, that leaves a little bit of doubt in my mind.
Judy, who are you addressing that question to?
Probably Ramsey. It's on your
Okay.
sheet, your spreadsheet.
Okay.
Point number 4, the very last sentence. And I'm just concerned about the word sufficient. Is that normal lingo, or is there something that can be more reassuring than just sufficient?
I'm not sure what word you would want. We found that the easements after review were, as far as language, location, were satisfactory, met all of our requirements, and complied with the intent of the town board condition of the incentive zoning. So I would say it met the requirement of the incentive zoning conditions that were put on the project by the town board regarding the filing and review of those easements.
Okay, I guess I just wondered how sufficient is. So, okay.
It was very sufficient.
Okay.
That
That makes me feel better. All right.
Okay. All right. So what else do we have as far as anyone interested in speaking regarding this application?
Danny Daniele here. I'll make it quick because I know there's a dozen people from the town of Brighton looking to use the zoning board for what's it properly supposed to be used for, not for Wegmans funded lawyers to try and postpone grocery stores. But the biggest point I want to make is the easement in the back of the property that everyone calls the Auburn Trail. That is a shared use easement. That is not just because the other attorneys weren't making this very clear, it's not just an easement for the town and its pedestrians. It originally was train tracks. It belonged to then RG&E. Then it was a part of the businesses that were there, and then it was part of the easement given to the town. So the businesses were there first. And just like you would see in many towns or cities where you'd see a sidewalk be installed in the front of people's driveways, let's say on the side of the road, and they put a sidewalk through your driveway, that doesn't mean that you're no longer allowed to drive over your driveway. That means that that's a shared easement so that you can drive your car onto the road, and they've also added a sidewalk for the pedestrians to use. This easement that's back there, it's a shared use easement that's not only supposed to be for RG&E to come in with their trucks anytime they want to fix the wires and trim the trees, but it was next given to the businesses for them to use. And it specifically says on there for the use for traffic, parking, movement. So there's nothing illegal with cars driving on there. One of the board members mentioned earlier that for years and years, people have been walking through there, going through parking lots. And the attorney made it seem like, well, it should have been parkland. No, that should have been a shared use easement. Just like you would see a sidewalk on your driveway, you don't turn that sidewalk into parkland. That easement in the back of those properties is a shared use easement where you are allowed to park vehicles there. You're allowed to walk through it, and RG&E is allowed to do whatever they need to do. The businesses were there first. And then as goodwill gesture, while they did other items through construction, the businesses said to the town, yes, I will allow an easement through my property so that people can walk through it to make a convenient passage for the Auburn Trail. So I just want to make sure everyone's very clear that it doesn't get convoluted, that any businesses around there, to whether it was the bowling alley or Mama San's or the animal hospital or Mario's, that somehow treaded upon this easement that they weren't allowed to. It was first the businesses and then it was the town's easement. And for the past 25 years, it's been shared very well between everybody. Not only is that going to continue, and unfortunately, the attorney kind of misled you to think that there are parking spaces that are going to be on this easement. There are no parking spaces on it. It's going to be very similar to the way it was before, only cleaner and better. And in addition to that, we've built a second trail that's literally 10 feet away to start with, which I believe most people would use unless you're someone being paid by Wegmans to walk through the parking lot instead of taking the beautiful trail 10 feet to the right. So I just want to make that very clear. And for the rest of all this stuff, it's all in the courts. I think what the attorneys are trying to do is use this board to make their case because they're losing in the courts. So they're coming to you, hoping to confuse you with all their facts to make it seem like, oh my gosh, the town screwed this whole thing up, when in fact that's not true. And frankly, it's disgraceful for the amount of time and work the town has put into this project to help the community, to raise tax base. They are using this town, this board, and unfortunately, they're stealing the time away from all these people who are on this meeting tonight. We're going into 10 p.m. Everyone's got work to do, and they're using all of our time for their own agenda to stop competition, and it's disgraceful. Let the courts decide. How the hell could you guys do it otherwise? Thank you very much.
Okay, thank you very much. Okay, Jacob, I see you have a hand here. Rebuttals are not allowed as it relates to this part of it. If you have something new to add, that'll be fine. If not, it is not fine. So go ahead.
I'm not going to respond to Mr. Daniele. I will say that everything that we represented in good faith. The easements regarding the Auburn Trail are instruments that speak for themselves. And if the ZBA would like to review them or would like further briefing on the legal effect of those easements, I would be happy to provide them. But I don't think that we should be analyzing the legal effect of documents based on someone's memory or comments. To close out, I'd like to thank all the board members for their time tonight. I'd like to thank, Ramsey, Boehner, and Mr. Mancuso, and all the other attorneys and townspeople who spoke tonight. I appreciate the opportunity to address you. Hope you have a good evening.
Mr. Mites, this is Mr. Rosenbaum. I'd like to make just one or two comments.
Go ahead.
Thank you. Again, this is Warren Rosenbaum from Woods Oviatt Gilman, attorneys for the developer. I wanted to, number one, I wanted to keep it short. I want to incorporate by reference into the record on this 980420. I want to incorporate by reference the statements I made in the prior application into the record on this application. That's number one. Number two, I think what Mr. Zoglin had to say regarding the access easements represents or demonstrates a fundamental misunderstanding of basic real estate law and really descended into gibberish in my view. I think you have a very competent attorney for the Zoning Board of Appeals, Mr. Dollinger, who's a very experienced, knowledgeable real estate attorney. And I understand that at least one of your board members is also an experienced real estate attorney. And I certainly would defer, I would ask the board to defer to their judgment in terms of whether or not that those access easements are indeed valid easements. Thirdly, I don't think that there's any question that one of the board members asked if the issuance of the building permit itself for Starbucks would impact traffic. The answer is obviously no. The only thing that would have any impact on traffic is if there's actually traffic coming in and out of the Starbucks. And until there's actually a certificate of occupancy issued and customers start coming in and out of Starbucks, there obviously will be no additional traffic. And when the town ultimately issues a certificate of occupancy someday, and I'm assuming that we'll hear from our opponents again, they'll probably take an appeal of that to the board as well. But unless and until a certificate of occupancy is issued, there's going to be no impact on traffic. And lastly, I just like to ask once again that the appeals taken by Brighton Grassroots be in all respects denied, and the issuance of the building permit be in all respects upheld by the Zoning Board of Appeals. And I thank you for your time.
Thank you, Mr. Rosenbaum. Okay, Is there anyone else that needs to speak regarding this application? We're
This is John Mancuso. If I may briefly, just to clarify for the purposes of the record, as with Mr. Rosenbaum, I would like to request that the statements made by Mr. Boehner, myself, and Mr. Guyon in connection with this application be incorporated by reference into the earlier Save Monroe application as a joint response for both appeals.
Okay. Yes, that's fine. And we did acknowledge that early on when that request was made by Mr. Boehner. So we'll make sure that that's duly handled.
I
Okay.
made a similar request with respect to the SMA and having our comments incorporated there and vice versa as well.
Okay. All right. So I think we can wrap this up at this point then. At this point, we'll close the public hearing and move along to the next application.
Everyone, thank you. Good luck with the rest of the night.
Thank you. Thank you. Okay. Rick, you're up.
Okay, you guys ready?
Yes.
Application 10A0320, application of Chris and Nicole Fitzgerald, owners of property located at 177 Commonwealth Road, for one, an area variance from section 207-11A to allow an in-ground swimming pool to encroach 4 feet into a front yard or not allowed by code, and two, an area variance from section 207-2A to allow a front yard fence to be 4 feet in height in lieu of the maximum 3.5 feet allowed by code. I'll describe an application and plans on file.
Okay. Who do we have speaking for 10A03?
Hi, it's Chris Fitzgerald.
Yes, and our apologies, Chris, for how long this has taken. So please proceed.
Certainly. Basically, I've got a two-part request. As Mr. DiStefano indicated, we're looking to put a pool in. If you're familiar with the property, it's on a corner lot, and so the Ashbourne frontage is also considered a front yard as it extends beyond the line of the house there, the dashed line. When we met with the pool installation company and they did the layout looks like it'll encroach a maximum of 4 feet to the edge of the pool beyond the property line, the line of the house, which is like the 4-foot encroachment on that front yard. And there's an existing fence that's drawn on there, a picket fence that would be replaced. It's a 3.5-foot fence. It would be replaced with a 4-foot fence around the pool. But instead of having a fence within a fence or losing a significant portion of our usable yard there, we were requesting that we be able to replace the 3.5-foot fence with a 4-foot fence to meet the pool requirement, but asking for the exception on the 3.5 code requirement.
Okay.
Just for the record, Chris, you understand that you cannot put that 4-foot high fence into the Ashbourne right away?
I do. I see. I recognize where it is. And for the record, I didn't install that fence there.
Understandable, but your 4-foot high fence will have to stop at your front property line, cannot go into the town right away.
Got it.
Okay. So questions for Chris by the board members?
Yeah. Chris, when I stopped over and I was talking to Nicole, are you going to have it kind of a wood color, natural color to blend in with the vegetation there, the trees and such? Or had you thought of a different color or what?
For the fence?
Yeah.
Oh, yeah, we are planning on wood. We don't know if it's cedar or pine at this point.
Okay, but a wood. Okay.
Yeah.
Thank you.
Okay. Other questions for Chris? Okay. Chris, thank you.
Thank you.
All right. Is there anyone in the audience Is there anyone on the call that went, boy, oh boy.
You'll get it right.
I'm all right. Is there anyone who would like to speak regarding this application? Okay, then there being none, then the public hearing is closed.
Thank you.
Okay, thank you.
Thank you.
Rick, go ahead.
Application 10A0420, application of Brian and Sarah Costello, owners of property located at 281 Pelham Road, for an area variance from section 205-2 to allow a garage addition to extend 18.25 feet into the 58.5-foot rear setback, where a 60-foot rear setback is required by code. All described in application and plans on file.
Okay. Costello, Mr. and Mrs. Costello?
Correct.
Hi, go ahead, Brian.
We are actually looking to construct a garage off the back of our house that actually connects to the current one-car garage that's there. And we're requesting a variance because it encroaches on the backyard, which has a 60-foot limit. And we're looking to just lower that limit to 40 feet because the garage is about 20 feet.
Okay. Just one quick question. I mean, did you look at any other alternatives of how to do a garage on the house? Were there any other things you considered besides this ultimate decision?
Yeah, we did look at another. We had drawings for another garage that would actually be on the driveway, but due to the variance on the left side, which is 5 feet from the neighbor's house, and also the fact that it would require the same variance, we decided to attach it to the house, which would be less intrusive on the yard and also a better view from the street.
Okay, very good. Okay, board members, questions?
Yeah, Judy, I just have a question. Is this going to go right up to where the rocks are before it dips down? Are you going to have to go out beyond, where it dips?
It'll be about a half a foot past where the rocks are.
Okay, thank you.
It won't go past the edge of the driveway though.
Okay.
Okay, other questions?
I have a question. I'm just wondering if you could describe for the record the need for the second garage. Why are you building an addition?
To park my car.
There's an existing garage, so I take it there are 2 cars.
There are 2 cars.
And have you spoken with any of the neighbors?
Yeah, I spoke to all the neighbors.
And does anyone have any objections?
Not at all.
Thank you.
Okay, John, thanks. Okay, other questions? Okay, good. All right, so is there anyone on the call that would like to speak regarding this application? Okay, there being none, then the public hearing is closed.
Thank you.
Thanks.
Application 10A0520, application of Marissa and Serge Sussman, owner of the property located at 110 Oak Lane for an area variance in section 205-2 to allow a garage addition to extend 2.5 feet into the existing 12.6-foot rear setback, where a 60-foot rear setback is required by code, and extend 3 ± feet into the existing 18.1-foot side setback, where an 18.75-foot side setback is required by code. All described in application and plans on file.
Okay. Who do we have speaking for 10A05?
My name is Serge Spossman. I am actually an employee of DesignWorks Architecture, but I'm presenting my personal home.
Okay.
Today. We'd like to add a 2-car garage to our existing home. Currently, we have a 1-car garage that was added to a 1-car garage that was at some point turned into a mudroom, and the feasibility of parking has just been exhausted. So we're looking at an opportunity to make it logistically more functional for our family.
Okay.
And no other alternatives actually would work and allow us to physically pull in a vehicle better than this arrangement at the moment. So.
Okay.
Sir, just for the record, could you kind of explain the impacts to the rear property and to your neighbor's property?
Yep. The rear of our property is a 25 foot concrete retaining wall that is the border between us and 490. So the property setback is actually not the retaining wall. It's actually depends on where you are in the yard, as you can see in the survey. We could be, in this particular northwest corner, we are there's an additional 4 feet to the wall. So we're not encroaching on any other property to the rear. Don't think it would affect any of our neighbors. I did get a note today that I forwarded on to Rick from from lot 6, which is our direct adjoining neighbor, in support of the project. We had them over and walk the site and show them what the implications would be, and they were grateful, and they don't have any issue.
Okay.
The side yard setback increment is an additional 4 feet, or actually closer to 3 feet additional into the non-conforming side yard.
Okay. All right. Board members, questions?
Judy, are you going to incorporate the existing garage into space for the house, and are you putting anything above the addition?
We're not proposing to put anything above,
Okay.
but we are going to incorporate some of the existing garage as a mudroom for our home for circulation.
Okay.
Okay, questions? Okay, very good. Thank you, sir.
Okay, thank you all.
Is there anybody on the call that would like to speak regarding this application? Okay, there being none, then the public hearing's closed.
Thanks, everybody.
Thank you.
Application 10A0620, application of Christopher and Rebecca Hayes, owner of property located at 41 Midland Avenue for an area variance from section 205-2 to construct a shed in a side yard in lieu of the rear yard is required by code. All described in application and plans on file.
Okay.
Hey, everybody. Hi, Rebecca Hayes, Chris Hayes.
Okay.
I think we can keep this pretty brief. We don't have a garage, so currently we don't have any storage for things like lawnmowers and other equipment, sporting equipment. As you can see from the survey, we also don't have a rear yard. The house is almost on the back property line. So we're just proposing to install a shed in the side yard, but at the back of the property. We are the last house on a dead-end street. The side that the shed would go on is the side where there's nobody past us. The street behind us, Willard Avenue, the lot directly behind us is currently a house under construction. It's the last home in that new development on Willard Ave. But the developer has already planted a row of trees on that property for privacy to us. So really, I don't think anybody will have a view of this shed. And it'll just serve our needs for storing things.
Okay, very good. Okay, do the board members have any questions? Pretty straightforward. Okay, great. Thank you very much.
Thank you.
Thank you.
Is there anyone who'd like to speak regarding this application? There being none, then the public hearing is closed.
Application 10A0720, application of Terry Zappia, Pierpont Visual Graphics Incorporated agent, and NBC Canal Holdings, owner of property located at 140 Canal View Boulevard for an area variance in sections 207-10A1 and 205-8 to allow an awning to extend 12.2 feet into the 75-foot front setback required by code. All described in application and plans on file.
Okay.
Hi, it's Terry Zappia from Pierpont Visual Graphics. And I'd like to probably have Mike Zangi from Highland Hospital and the University of Rochester speak on behalf of this awning that we want to extend out in front of the building. Mike, are you there?
Yes, I am.
Okay, so are you going to introduce the application, Terry, or is he going to?
He was going to.
Okay, very good. Could you just, sir, could you give your name so that Rhoda can get it, please, and your address?
Sure.
Michael Zengi, Director of Real Estate Services for the University of Rochester Medical Center. The address is 135 Corporate Woods, Suite 160.
Okay, go right ahead then.
Okay, so we are asking for a variance to allow a canopy to be installed in the front yard of 140 Canal View Boulevard. This will encroach into the front setback requirement. The purpose of this canopy is for medical center staff to deliver medications to patients in that front driveway that you see there. And the reason for that is actually due to COVID. We've gone to a new process where medications are delivered to patients at their cars so they don't have to enter the building and potentially be exposed to other patients who could have COVID. So the idea is to increase social distancing for these patients. These are cardiac patients who could actually be at very high risk for COVID. And this is a process that we've implemented about 4.5, 5 months ago, and it's been working well. But we know that inclement weather is coming up, so we want to provide protection to our staff members who come out of that door at the front and deliver those medications to the patient's car side. So that's our what we'd like to do and the purpose of that.
Okay, so can we be probably assured that the size of this awning is the minimum that's necessary to serve this purpose?
Yes, it covers the sidewalk only.
Okay. All right, board members, questions?
No question. I'm just wondering if you could talk to traffic flow at all, or is the idea that the cars would pull up parallel with the building so that the staff would stay under the awning, or would staff need to go out to a parked vehicle? And I'm just wondering if that has any impact on the number of parking spots, including handicap parking.
Sure. So it's been working quite well. Currently, they have a couple cones out in the driveway, so that indicates to the patients that they pull up right to the end of the sidewalk where the awning would terminate. There's not a lot of traffic in the front here. All the parking's in the back, and the entry to the property is in the back. So it's a pretty underutilized driveway. No parking would be impacted either.
Great, thank you. Questions, board members?
This is Member Wright. You mentioned that this policy of delivering medications and the need for this awning was sort of spurred by COVID, but do you anticipate that this awning and the use will be long-term, whenever the post-pandemic happens, I guess?
Yeah, and it's actually been really a patient satisfier, just from a convenience standpoint. So we anticipate it remaining up permanently in this process, continuing permanently.
Okay. Other questions, please? Okay, thank you very much. Appreciate it.
Thank you.
Anyone would like to speak regarding this application? Okay, there being none, then the public hearing is closed. Thanks.
Application 10A0820, application Mark Anderson and Randy Foreman, owners of property located at 257 Dunroven Lane for an area variance in section 205-2 to allow a screen porch to extend 10 feet into the 60-foot front setback required by code. I'll describe an application and plans on file.
Okay. Who do we have for 10A08?
Mark was there.
David. So architect David Burrows, I believe, is on the call tonight. David?
Yes, I'm here.
Okay. Who is speaking on behalf of this?
I am Come on.
David?
Yes, I'm here. Can you hear me?
Yes,
we can.
yes, please proceed here.
Okay, good. Sorry, I didn't know that. So anyway, I'm David Burrows, working with Mark Anderson. Sorry for that confusion. Mark asked me to design a open porch that can be screened seasonally, that will be in the front of the house. I believe the other drawings are attached with this so that you can see the photographs of the house and the configuration of the proposed porch. The idea is to kind of help the front with formality and just kind of correct some of its asymmetry and call more attention to the front door. So the roofs work with the existing facade. This has been before the Architectural Review Board and passed with conditions, and those conditions have been addressed. The reason we're in front of the zoning board is there's a 60-foot front setback, and we will be at somewhere between 49 and 50 feet at the closest part of the porch to the front property line. And that front property line is curved because this is a cul-de-sac, or it's a curve in the road anyway. So, so we're still a good 50 feet from the front property line, and hopefully have done a good job of mitigating the impact of the porch on the front yard. And I'd be happy to let Mark make his comments as well.
Okay, go ahead, Mr. Anderson.
Yes, good evening. Yeah, the porch is an area that we've desired. We looked at the back side of the house. The roof lines in the back would not accommodate the porch. So the front is sort of by default where we would need to put it. We did try to make it as appealing as possible. The Architect Review Board suggested we keep the screens as open as possible and removable. We've agreed to that, and they also asked us to keep the door in front of the existing door for aesthetics, and we agreed to that. I think that's all I need to say.
Okay, great. All right. So, board members, questions for these gentlemen?
I have a question. Are there any other structures close by that extend closer to the front setback than what currently exists? Are you going to be matching some other structures, or is this going to be the only one on the street or in close proximity?
Yeah, in close proximity, there are no other front porches like this.
Any additions of any kind that extend closer to the road, or is the frontage pretty uniform throughout?
The frontage is uniform throughout.
Thank you.
I could comment on that, however, that
Sure.
there's a variety of house styles in the neighborhood. So it's not like there's any uniformity that this needs to conform to. I don't think it'll stand out as unusual in that it would have a front porch.
Yeah, I wasn't so much concerned about the porch itself, it was just the extension of 10 feet into the setback, the uniformity of the setback that's along the street.
Yeah,
Okay.
I like Mark said, I don't know of any others in the immediate vicinity that would be as close as this.
Okay. Very good. Other questions by the board, please? Okay, very good. Thank you very much.
Thank you.
Is there anyone that would like to speak regarding this application? Okay, there being none, then the public hearing is closed.
Application 10A0920, application Marco and Anna Frasca, owners of property located at 333 Rhinecliff Drive for an area variance from section 205-2 to allow a two-story addition to extend 2.3 feet into the 9-foot side setback required by code. Also described in the application and plans on file.
Okay.
David, go ahead.
Okay, David Burrows, architect for Marco and Anna Frasca, who I believe are also on.
Yeah, we're here.
Okay, good. I would like them, Marco and Anna, to basically describe the need for the variance and what they propose to have built, and then I'll talk about some of the details.
Okay, go right ahead.
We have a 3-bedroom, 1.5 bath house today. And we'd like to do an addition for adding a master bath, bedroom, closet, and mudroom to the first floor. So we'd like to push out one of the walls, and we're allowed to go 1.3 feet today, and we're asking for an additional, we're allowed to go 1.7 feet, and we're asking for an additional 2.3 feet to implement all of the designs that David has put together for us.
Okay, very good. Go ahead, David.
Sure. So, right, the allowed setback is, required setback is 9 feet. It's presently 10.7. We are adding 4 feet to the house, and we'll end up with 6.7 feet for the side setback. I guess the good thing about that is it's in the back of the house. It's not close to the street, and it only impacts their neighbor's driveway and garage. And there's kind of a dead zone in that part of the shared border anyway, because there's arborvitae up against it. There's really nothing happening back there. So this will really have no impact on the neighbor. And the reason that we're encroaching on the setback is to allow the depth of the car and room in the back of the garage for storage and room towards the house for mudroom. And that shows up on other plans that are included in this set.
Okay.
Right. If you needed to see the photographs, they're helpful because they show that there's really nothing, especially the bottom right photograph that shows the area where the proposed addition is going to be built. And then the one in the top right is the street view. Again, you're not going to really see anything from the street.
Oh, in the bottom right photo, that's the detached garage of the neighbors, correct?
Right. The top right and the bottom right photographs are taken from opposite corners of the yard, right along the property line.
Okay.
Quick question, this is Member Wright. Can you speak to why you can't go in the other direction? I think it's the northeast of the property, further into where the blacktop and patio are?
Sure. If you look at the floor plans, that might answer the question. Part of it is the site itself doesn't allow you to back up a car any tighter than it already is. But the other reasons are the way that it connects to the house, especially in the second floor plan. And one of the goals was to build a master bedroom above the garage. So that on the top left corner of the second floor plan shows the second floor lining up with the existing existing face of the garage, face of the first floor. And the back of the back of the second floor allows room for a hallway towards the top and the master bedroom suite itself. So just because of the way it connects to the existing house, we're kind of forced to go in this direction anyway.
Okay. Other questions for these folks?
David, you did check your livable floor area and that's all meets code?
Yes, I did the single family zoning information form and we're under.
Okay, thank you.
Okay, very good. Okay, well then, thank you very much.
Thank you.
Okay. Is there anyone who would like to speak regarding this application? Okay, there being none, then the public hearing is closed.
Application
Thanks, and good
10A.
Thank you.
Application 10A-1020, application Jennifer Hansen, owner of property located at 1050 and 1054 Highland Avenue for an area variance in section 205-2, to allow a side setback to be 11.8 feet after re-subdivision of two properties into one in lieu of the minimum 21.88 feet required by code. I'll describe an application and plans on file.
Okay. Who do we have on 1010?
I don't see Jennifer here.
I don't see Jennifer Hansen on the call.
Okay. All right, well, why don't we pass it and then we'll come back at the end and see.
Okay. Application 10A1120, application to the University of Rochester, owner of property located at 220 East River Road for a temporary revocable use permit pursuant to section 219-4 to allow a mobile MRI scanner to be on site for an 18-month period where not allowed by code. I'll describe an application and plans on file.
Okay. Who do we have on U of R?
This is Dan Savage with Passrow Associates. We
Okay.
also have Walt Petit with University of Rochester Medical Center, and Tim Harris, project manager with Passrow Associates. What we're asking for here is a temporary revocable permit to allow the university to install a mobile MRI trailer. Due to the pandemic, they have a large backlog of MRI cases that need to be done. They have the availability to have this trailer for the next 6 to 18 months to help them work down the backlog. The trailer would be carted to the site. The site would be prepped with a concrete pad and utilities that would come out of the existing imaging building to service the trailer. There is a rear exit at the building. Patients would come in to the front of the building, get processed, get in gowns, and then be transported by staff out the rear door through an enclosed canopy to provide some comfort during the winter weather, and proceed to the MRI trailer. And then once their procedure is done, they'd go back through the building and exit out the front of the building. We did look at other options. This option here presented the closest connection to the building, again, to minimize the time patients and staff would have to traverse outside in inclement weather. After they no longer need the trailer would be hauled away. The concrete pad would remain. University is thinking that they could put some picnic tables out for staff that may want to use that for lunches or what other in the future.
Okay. Very good. So
This is Member Dale. I just had a question about the covering of the walkway. Is that going to be? Is it going to be lit? Are there going to be sort of like sides to it? I'm just thinking about the patients and if it's quite cold. If it's quite cold out and it gets dark at 4 p.m. In February.
Yes, it's a good question. It will be made out of flame-resistant fabric, and there will be lights strung inside the enclosure. They do anticipate running the MRI procedures approximately 12 hours a day, so that we'll need lights turned on inside the canopy.
So it's not just a covering. Are there sides as well?
There are sides.
Okay.
Yes.
Okay, other questions?
Just a couple questions. Do you have, you're removing a couple trees there. Do you have plans to relocate those trees?
Yes, we have ample opportunity around the building where we can replant those trees. They're fairly new, and the university would like to use them in other locations on this site.
And the second question is, you're asking for 18 months. When do you expect this trailer to be located on site?
Well, the trailer is currently down at Noyes Hospital in Dansville. They're going to be using it into the month of November. If we're able to get approval from the board, university intends to proceed quickly to start preparing the site, ordering the canopy material, and get it ready for when it gets delivered from Noyes Hospital to this location.
Any idea when that's going to be? I mean, are you like, you got to prepare the site. You have to do some work before you can even put it there. Are you thinking by December 1st, just so this board has an understanding of what they're granting the time period that they're granting the TNR for?
Yeah, I would say sometime in the month of December, we would expect for the trailer to be hooked up on site.
And start using.
Yes.
Thanks.
Sorry, just one more question. Being that you requesting this because you've got a backlog of patients, and that's certainly understandable. Are you anticipating any issues with increased parking as there's more patients coming to this location than perhaps would normally?
We don't think that's a concern because right now parking is reduced because of the pandemic, and any increase from patient throughput would be more than accommodated with the parking spaces that are on site.
Thank you.
Okay, is there any other questions? Okay, thank you very much. And is there anyone who would like to speak regarding this application? Okay, there being none, then the public hearing is closed.
Okay, application 10A1220, application FSI Construction, Frank Convergia, owner of property located at 3300 Brighton Henry Town Line Road for an extension of approved variances pursuant to section 219-5F, required for the construction of a 10,000 square foot office building. I'll describe an application and plans on file.
Good evening, everybody. Tim Harris with Pastor Associates here representing FSI Construction and Berger Brothers Holdings. This project received 3 variances about a year ago for parking in the front yard, building encroachment into the front setback, and encroachment into the EPOD. Since that time, excuse me, the developer has received or has signed up a tenant to occupy the building. They will be pulling building permits in the next month or 2 here, so they're all set up and ready to go. The reason for the extension is to grant us a little bit of time to pull those building permits as the developer has just recently entered contract with a tenant. So just asking this board for a short extension of the 3 variances previously granted about a year ago. With that, I can take any questions from the board.
Okay. So nothing has changed at all on the original plan or the variances that were granted, correct? Mr. Harris?
He's muted.
Oh, you gotta take your mute off there.
There we go. Yeah, it wouldn't let me there for some reason.
Okay.
I apologize for that. Rick was trying to keep me quiet. No, you are correct. Nothing has changed in the last year on the plans. Literally everything has stayed the same, and we would like to move ahead with the plan as originally approved.
Okay, very good. All right, any other questions for Mr. Harris?
Hey, Tim, I find that very hard to keep you quiet, so.
All right, well, we're gonna do it anyway. Okay, very good. Thank you very much. Anybody in the audience? Oh boy. Everybody, anyone who would like to speak regarding this application? Okay, there being none, then the public hearing is closed.
All right, thanks, everybody.
Thank you.
Application 10A1320, application of Ken Stavallari, Home Power Systems agent, and Sandy Hauk, owner of property located at 290 Hibiscus Drive for an area variance from section 203-2.1B6 to allow a standby emergency generator to be located in a side yard in lieu of the rear yard behind the house as required by code. Also have an application and plans on file.
Mr. Stavallone.
There we go. I got unmuted.
Wow, you're still awake. That's nice.
I was in my pajamas.
Yeah, that's good, Ken. That's good.
Thanks. I appreciate it. Tonight I'm proposing to be able to place a generator on the side of the home here, obviously against the current code saying that it needs to be placed in the rear of the house. Due to the uniqueness of this house there, as you can see, it's an L-shaped building, and there's a pool there with concrete all around there, and we wouldn't be able to meet any of the code requirements with the generator in the rear of the house there, as well as a garden shed. On the side for the proposed location of the generator, there is a large bush evergreen that in front of it that you really cannot see the generator from the road. And as well as on the left side of the property line, it is all heavy shrubs and shrubbery, and it would be very, very limited visibility from the house on the other side. And that house is a great distance away. I would estimate it over 100 feet. And then in addition to that, the generator would not be into the side setback requirement there as well, because there's a decent amount of distance between the house and the property line there. So and I'm willing to take any questions.
Okay. Everybody's
Can you
running
say-
out of gas, but do we have any questions for Ken? Because, he needs to earn his paycheck.
Yeah, can you state for the record what the decibel level on that generator would be?
Absolutely, sir. 65 decibels.
And that's at full load?
And that's at full load, correct.
And
Sorry.
go ahead, Judy.
I'll ask you a question. Also, did you give consideration to the placement because of the utilities being right there?
Absolutely. Yeah, that is very correct, Judy. And as you can tell, the utilities are right there as well. And it would be a further run for the homeowner to try to, essentially, if we wanted to do it in the back, we'd have to trench and set the generator almost in the middle of the yard, kind of. So, great question.
And what is the size of this generator?
It is 4 foot long by 25 inches
No,
wide.
I'm sorry, what's the kilowatt?
Oh, I'm
size?
sorry. Yeah, 16 kilowatts.
16 kilowatts, and you feel that you'll have a minimum 10-foot setback from that lot line?
We will have no issue hitting that.
Okay, very good. Other questions?
Just one quick one.
Absolutely.
Can you just confirm that you're planning on keeping the landscaping that will be kind of hiding the generator from the street view?
Yes, absolutely. I've spoken with Mrs. Hake about that, and she's in full agreement to keep that there. And she actually likes the fact that it's blocked there.
Thank you.
Yep.
And this is Member Wright. Sorry, one more quick question. There was an email sent, I believe yesterday, from a neighbor of the property suggesting that the generator could be fit in between the home and the garden shed. Can you speak to that?
Yeah, absolutely. So with the current fire codes and the distance between the home and there's a couple reasons that go into play. With the current fire codes, the units themselves are rated 18 inches, but they have to be 5 feet from any windows or openings. And to place it in between the garden shed and the home there wouldn't meet that 18-inch requirement on either side for fire code. And in addition to that, for serviceability, obviously if there happened to be a major repair that needs to get done, with it being in that tight space, it would make it nearly impossible for us or for the homeowner.
And what is that space? Only because we have an email from a neighbor saying it's at least a 10 to 12 foot gap. So
Yeah, absolutely. That's a fair question. I don't have that exact number for you, but I don't believe it is 10 to 12 foot. It's hard because it wasn't on the original, it's not on the map.
Okay, we all set there? Okay, all right. Thank you very much, Mr. Stavallone. And is there anyone else who would like to speak regarding this application? There being none, then the public hearing is closed.
Application 10A1420, application Sean and Lauren McCabe, owners of property located at 3395 Elmwood Avenue for an area variance from section 205-2 to allow a garage addition to extend 2.5 feet into the existing 36.1 foot rear setback, where a 60-foot rear setback is required by code. I'll describe an application and plans on file.
Okay.
Hi, good evening. It's Sean McCabe. I'm the homeowner at 3395 Elmwood. Thanks to the board for hearing us tonight, and I applaud you for your endurance. You able to hear me?
Yes, go right ahead.
Okay. We are seeking a variance tonight for an addition for a two-car garage. We're not able to fit our vehicles in our existing garage that came along with the house when we bought it. Due to the orientation of our lot, we're on a flag lot, and the orientation of the house, there's not really a better place on the property to put the garage without some serious site work and without reconfiguring the driveway. This addition is going to be consistent with the architecture of the house and the residential nature of our neighborhood, and it won't be able to be seen from the road. I think only 2 of our neighbors will be able to see it. Trying to think, it's the minimum variance necessary just because of the location, with making it work with the architecture of the house and the rest of the addition. This is sort of the only spot it can go, and I believe the variance is actually smaller than the one that was previously granted in 2017.
Okay. So questions for Mr. McCabe?
Can you just state for the record approximately how far away this garage addition would be to the nearest neighboring structure?
The nearest neighboring structure, I am not sure. I think it would be 500 feet.
Okay, thanks.
Maybe could be slightly smaller than that, but the neighbor behind us to the south is there's a row of arborvitae between the 2 homes, so they wouldn't be able to see it.
Okay. Quite a bit of distance.
Quite a bit of distance, yes, correct. I can't see the map. I don't have it in front of me. I'm looking at the small version that I've got on the screen. I don't even know if the neighbor's house is reflected on there.
It doesn't look like it.
Yeah.
Okay.
Thank you.
All right. Any other questions for Mr. McCabe? Okay. Thank you very much.
Thank you.
Is there anyone who would like to speak regarding this application? There being none, then the public hearing is closed.
Application 10A1520, application John and Dina Wright, owners of property located at 3644 Elmwood Avenue for an area variance with section 205-2 to allow an addition to extend 3 feet into the existing 52-foot rear setback, where a 60-foot rear setback is required by code. I'll describe an application and plans on file.
Hi, I'm Dina Wright, homeowner. Can you hear me?
Yes.
Okay, great. So we are proposing to build a small addition that's going to be a home office. As you can see in the plan, it basically fills in a little dead space that was present in the original house. And we just wanted it to extend 3 feet beyond the original line of the house. The original house was, I believe, 52 feet from the rear of the property. So it was already kind of less than the setback was required by code. I assume it was grandfathered in because it's an old house. But there is, so we want to go an additional 3 to 4 feet. I guess the architect asked for 4 feet, even though we're only going 3 feet. And there is nobody, there is no house there behind us, directly behind us. That property in the back there is just scrub brush and trees. There's nobody could see this from the road. It's So, and on the right side of or, as you're looking at it, on the east side there is the parking lot for the Country Club of Rochester. So I don't think they would care either, and there's a fence separating us. The need for the office is that we have a 3-bedroom house. There's 4 of us living in the house. My son is working partially doing school from home, and I am a professor and I'm teaching from home as well. And so, with COVID, the need for a home office has really gotten to be much bigger than it used to be.
This is Member Wright. Just a quick question. Is it fair to say that based on the fact that this expansion is being tucked in between 2 portions of the house, there isn't another area of the house where it could be added that it would be less noticeable, probably?
No, there isn't. Yeah. This is really very, you can barely see it, I think, from anywhere once it would be completed.
Okay. Other questions for the applicant? Okay. Is there anyone else that would like to speak regarding this application? Okay, there being none, then the public hearing's closed. And I'm just going to ask again, Rick, about 10A10. Is there anyone to speak to 10A10?
I do not see
Okay.
the applicant online.
Okay, well, we can deal with that one then as we go through. Okay. All right, we have reached the end of the road here. Does anyone need a couple of minutes, or do you want to just proceed?
Can we have a couple minutes?
Yeah, I think we all could.
I think we
Okay.
need to stretch. Yeah.
Okay, it's 10:52, so why don't we stay right at 11 o'clock, okay?
Okay.
Well, Rick, can we do this in an hour?
I hope so. It's fairly straightforward. I mean, I don't know how much discussion is going to be required.
Or we with the apartments?
Yeah, we got to do the apartment. Rhoda, are you out there? Didn't lose Rhoda, did we?
I think Rhoda's still on her phone.
Okay, so yeah, I was just going to ask you if one of those was her phone.
I think the
Just want to
9
make sure she's still there and still ready to finish this off.
Yes, my phone is working.
Okay, Rhoda, I just wanted to make sure we didn't lose you.
Yeah, I'm having internet connections. I'm glad I had the phone on. But I don't know how to unmute myself through the phone.
I just took off the goal restriction on unmuting, so you should be able to unmute your phone now.
But I don't know how to.
Oh.
Am I?
One sec.
Got everybody? Are we ready?
Yeah, let's get started. They can work on the phone thing.
I'm all set.
All right. All right, Rick, we'll start with 9A03, which is the garages on
Monroe.
Monroe Avenue. Okay, so let's try here. We got a lot to do here, and we'll try to finish this in an hour. So let's just move right along. If you have something to add, then fine. Okay, comments? Because I'm not going to go around one by one here. It's going to take us forever if we do that. So.
Well, I think from the last month we had like a 3-2 vote on this. Jennifer, you weren't here. You know, with the new landscaping plan that was submitted, how do we, you know, I think Catherine and Judy, you were the not feeling good about it.
Right, I still deny it.
Okay. All right, Kathleen?
Yeah, I have to say, I do appreciate the additional landscaping, but I don't see from what they provided that this wasn't as a result of their own creation and not either repairing or upkeeping it, putting in some upkeep. And I don't see why they can't fix the roof or whatever the problem is.
Okay, then I guess let's go through everyone else then. As you got 2 votes here to deny. Andrea?
I'm fine with it. I'd approve it.
Okay. Jen?
I regret not being part of the conversation last month or having any minutes to review that I could find. So I don't know the full discussion of the pros and cons, but I don't see anything glaring in it that would make me deny it. So it's a weak yes.
Okay. And Jeannie?
I'm good with it.
Yeah, and I'm good with it also.
Okay. Sorry.
Now, somebody's got to do it though, because it was Judy, so we can't ask her to do that. Anybody want to take a shot at this, or we can work together on it, I guess? Now, we'll start it up here. I move we approve application 9A0320 based on the following findings of fact. The applicant reports that the garages are in poor condition and that minimal storage is required by tenants in the property, and they're required to pay extra for these covered parking spaces. 2, if the parking structures are removed, no negative effect would occur on the immediate neighborhood, since it is a commercial neighborhood along Monroe Avenue, and additional landscaping will buffet the property to the residential area behind it. Help me out on one more thing here. Anybody got an idea? What do you think, Rick?
I think we need a little something more to beef it up, to be honest with you.
Yeah, that's what I'm just trying to think of, what else we could use here.
You comment that it's,
Go in.
did you comment that it's not, it's not substantial given the screening, doesn't produce an undesirable change due to the fact that the fence will be maintained in additional plantings so that neighboring properties won't be affected by the removal of it. Or both of those there.
Yeah, and we've got a little of that stuff. Maybe we could try something like, while parking is required for the residents of this apartment building, covered parking is not required.
No.
No.
No, parking, recover.
Oh, that's
parking
right. I
is
forgot.
required.
No, I forgot about that. You're right.
No,
You're
so
right.
scratch that one. Don't put that
Yeah,
one.
we can't do that. I remember now. Yeah, we talked about that last month. Okay, we just need one more thing here, I think. Just
I think what Andrew is kind of like on the substantial, not being substantial, and I think she was going with one that we could add in there. I don't know if Rhoda got it down or not, Andrea.
Oh,
So I
sure.
think- So Dennis's first 2, and then if you could add, this is a third.
Yep. Yeah, that's fine. Andrew's was fine. It was a little.
I just don't know if I think it little. I don't know if Rhoda got it down, and if we could just
You
like
wanna-
polish that one up.
Do you want, Rhoda, do you want her to read it one more time?
I'm good.
Okay. Okay, just try it one more time, Andrew.
The requested variance is not substantial, given the shrubbery screening and the fence that will be maintained, and the limited sightlines from neighboring properties.
Okay.
Okay. Conditions?
Okay, so conditions 1, this variance is based on the specific units to be removed in the location as noted on the plan submitted and testimony given.
I don't know if we need that one because these are the only one. All of them are being removed.
Oh, okay. All right.
So they're not going to have any.
There's not going to be any question. Okay. So number 2, then what permits do we need? Pardon me?
I think number 1 is we should condition it on getting planning board and conservation board approval for the landscaping plan.
Okay,
So the applicant shall receive planning board approval and conservation board approval in regards to the proposed landscaping plan.
okay.
That's number one.
All right. Number two is the fence that is currently on the property shall be repaired.
Shall be repaired and maintained.
Okay. What else do we need?
Repaired and maintained.
And if the planning board's going to go over
in
the,
perpetuity.
pardon me?
In perpetuity.
Yeah, that's fine. And the landscaping, I think if the planning board's got to approve it, we don't need to suggest that they've got to do the landscaping per the plan, so.
Right.
Okay, I think that should do
So
it.
those two. And I mean, we certainly could say all necessary demolition permit shall be obtained.
Okay, well, you should have said that in the first one then. Okay, go ahead.
Why? No, I wanted to say
Okay, I'm just
planning
busting.
board and conservation board approval, fence, and then all necessary demo permit shall be obtained.
All right, how about a second for this, please?
Yeah,
I'll second.
Okay,
Sorry, Jimmy.
doesn't matter.
The motion is to approve with conditions. Ms. Schwartz,
No.
Ms. Dale,
Yes.
Ms. Schmidt,
No.
Ms. Watson,
Yes.
Ms. Wright,
Yes.
Ms. Tompkins Wright, and
Yes.
Mr. Mites.
yes,
Motion to approve with conditions carries.
okay. Well, then we move into the first of the Monroe Avenue adventures here. So, given, I think, the complexity of trying to put this together, as well as, there's various pieces of additional information that nobody can even remember which part it goes with and whatnot. So, my thought here is that we table this again so that we can put together our, a real succinct presentation. I'm open for obviously discussion, not only about that, but about anything part of it. But I think the whole thing starts to come together, and I think we'll do ourselves a better service to table this thing. But would you like to entertain some discussion about it tonight, or how do you guys feel about it?
I think we should discuss it tonight while everything is sort of fresh, and then I don't necessarily disagree, because I've been writing this approval this afternoon, and or denial, like putting facts on
Yes,
paper
right.
this afternoon and tonight during the meeting, and it is a lot to make sure that's effectively communicated whichever way we go on
Right.
it. But I think we've spent a lot of time tonight on it. I don't think we should lose that and not talk about it at all.
No, that's fine. That's fine. Yeah, I think part of the problem is there's a lot of conflicting information, and it's not a question of suggesting who's right and wrong. Obviously we're going to have to come to that determination, but I think what's going to have to happen is to go back and really look at the presentations that were made on both sides of it. I mean, I think all of us are probably familiar with what the merit of all of this is, or what these applicants are trying to accomplish here. But, I guess the big question is, did the town do its job? Did it do it properly? And, is there any suggestion that their issuance of this permit should be reversed? So, okay, who else would like to talk about this, or what do you guys want to talk about?
If we were to table this, would the public hearing remain open, or would it be closed?
No, I think we should close the public hearing.
It's already been closed, right? So, yeah.
Well, we close it, we keep it closed. Yes, we do not reopen the public hearing. We keep the public hearing closed. But we do allow for maybe some additional information to be submitted, because again, we got very late submittals from the applicants. The building inspector has not had an opportunity to review that stuff and to comment on that particular information that's come in. So I think it's we should allow that to happen. Maybe give them a 2-week period to get any additional information into us, which then I can distribute to you guys.
Right.
And move from there. David, what do you think on this?
I agree completely, Rick. Exactly. You know, a response from the building inspector to the submissions. I think there were 2. I think Zoglin had 2 submissions, didn't she? One on the 25th and then one today.
Yes. Zoglin has submitted
So,
2
you know, the
additional
idea
submittals.
of giving Ramsey time to respond to that 25th submission and then the submission today is really reasonable, I think.
Right.
My only concern is, depending on what happens in the next month, is there going to be additional information to consider a month from now that we table it again, and at what point?
What point do we stop ping-ponging back and forth?
Yes.
Well, and that's why I say basically we put a limit, 2 weeks, it's done. We do not accept anything after a 2-week
Yeah,
period.
not only that, I mean, I think too, Rick, a limit on the issues a little bit too. I mean, I think
Yeah, maybe that's what you want to do.
You know, Ramsey gets a chance to respond to the new issues raised in those 2, but you know, I'm not sure I want to give anybody time to make a general response to this.
Okay. I have no problem with that.
Yeah.
If we want to table it and limit the giving the Ramsey the opportunity to address the latest submittals by Grassroots, and that's it.
Right. That's what I'm thinking.
Rick,
I don't know how the rest of-
will these things that you sent to us this afternoon still be on the our zoning board, older agenda? So, because I didn't print them out yet. Can we still access them after tonight?
You'll be able to access everything because it doesn't go away. It's up there on the site. If you go to, you'll be able to
Tonight's
access
meeting.
it. Also, I'll put that other stuff in the mail to you guys, tomorrow, Friday, so that you'll have it. The 2 other submittals, I will get that right out to you guys.
Oh, okay.
So you have some time with it.
Okay.
They did touch on most of the stuff in their presentation tonight. So we can handle it that way, but I don't know, Dennis, and I don't know where you are going with the board on this. I mean, we are going to have to craft findings. It's easier to craft findings if we know the direction to craft those findings.
Yeah. Well, I think that, again, I don't want to speak for anybody else here, but, at this moment, I mean, I agree with what you're saying. However, I think there's a lot of convolution with this thing. And, personally, I wouldn't feel confident at this moment saying how I really honestly feel about it.
Right.
Okay.
So I think, I think we're going to have to, I know we can't really straw poll and do things like that, but, it just means that all of us are really going to have to do just that. You're going to have to go back and you're going to have to really read through this and listen to the testimony, not listen to it, but, consider the testimony that was given.
Yeah, I question, I mean, does anybody have any questions of me?
Sure.
As I look at some of these things or Andrew, I mean, some of these things, and I don't know if I'm jumping into, but the efficacy of the easement because of the mortgage. I mean, I have a real opinion on that. And
I know.
Say that again, David. What did you say?
Well, the efficacy of the easement, given the fact that it has a mortgage hovering over it. I mean, and I guess the problem is, Dennis, a little bit, and again, I'll go any direction anybody wants, but it would be nice to have some sense of what people think about, whether, no, my feeling is, because we don't have to make the final decision, but they bring up like 5 separate points. And the question is, what do people think about the idea of the easement, their easement argument? I mean, what do you think of that argument?
Well, here's part of the problem.
Let's not do that till
I
later.
mean, obviously, being a real estate person, I have some knowledge, and I know other people in the room as well too. But it would probably be helpful. And please, if someone doesn't think it'll be helpful, but there's really some legal points here that a non-legal person is going to have difficulty, extrapolating here, related to the merits of this easement, or is it really a material problem that doesn't meet the test of what, the approvals on this project required? I mean, I guess if we asked you that, you would have a professional opinion about that, I guess. But what are the points that really need to be considered for one to be able to determine it, I think is probably the bigger problem.
Well, yeah, on that one, but then there's other ones too. I mean, just a general sense of, some of it's so complicated. The approval, that argument about the approvals, the state approvals, and they do such a good job. Dennis, I guess you and I have talked about this. They do such a good job of kind of conflating the language.
Yes.
I don't think for instance, I don't think that the amenity agreement or anything to do with the incentive zoning requires the state of permits.
Mm-hmm.
It just requires the approvals.
Right.
And when you read this, they're in the way they conflate the language. It's really, amazing. It's not a valid easement. I never heard the term valid easement. It's really fascinating to me.
Yeah, and it's also an interesting argument about the Auburn Trail and the mitigate, and there's it's certainly it's clever, okay, but I'm not sure that it's we won't use the word valid because I think we beat that one to death, but there are some interesting points to consider in that.
I'll just give, I think it was obvious. I felt very strongly about the cross-access easement issue because it's absolutely enforceable. And, I stare at easements more than I ever want to, all day long. And an easement by a property owner that's recorded would be considered enforceable. There'd be no way for the town to ever research whether or not speculatively in the future someone could argue that there wasn't
valid easement,
there could be a breach of a mortgage because of it or something. It would be completely unreasonable to ask a town to do those steps. It would be just as reasonable. One of the comments I made was for them to ask for an organization chart to confirm that whoever signed it wasn't a low-level employee who didn't have authority to sign over an easement. That's just not how life works. So I feel really strongly that that's a bad argument.
Yeah, bad. And in the way he keeps conflating the authority, because there's a default clause in there upon transfer of thing, that implies that you don't have the authority. That's just otherworldly. But it's amazing.
I think
and you're thinking, oh wow, yeah, he doesn't have this, it's crazy.
No.
So
and even the fact that he even the attorney even said this is contained in the covenant section of a mortgage. A covenant section means these are the things that I will do or will refrain from doing. It's not a bargain and sale of your rights away. It's agreeing that you won't do something. And if you do it, you can be sued. And there are consequences to it, but it doesn't, take away your rights vis-a-vis the rest of the world.
Right. Okay. And then I think, suggesting the rain cloud about the first mortgage or, potentially foreclosing or whatever. That isn't really material in this decision either, other than trying to slant you away from it. So
how about the phasing? Did everybody else?
Yeah, I thought the whole argument about the phases and the staging and all to be a little nonsensical. I don't know.
I looked at it as a matter almost of semantics in a way, and that to me, although they refuted it, to me it was sounded borderline segmentation. But after listening to it, I still think that there's a question about the phasing.
What question? What question?
I don't. All the permits haven't been pulled, right?
Right.
Okay, so to me, that should be done. And
the fact that they're doing the entire site work as part of this permit,
You do have to do that. You do, yeah.
That's the bulk.
That's all, guys. Here's the thing about the site work, though. I mean, a lot of that's an election, okay? So, you know, to say that you need to do all this site work right now, okay? Because that's not really entirely true, okay? And then the second thing is that, you know, no one could have whoever would have contemplated that this type of a project based on how many different buildings it is and what types of buildings, that you would be staging it every 2 months and having permits pulled and starting various pieces and parts of a plaza is never really done. Okay,
Right.
so that's kind of, if someone had that expectation, it was unreasonable to start with, and nobody practically would do it that way. In other words, you wouldn't necessarily build this building and never start any of the others, but you wouldn't start all of them at the same time. Okay, so.
Plus, I don't see how you could possibly imply phasing. I mean, that's an argument for the second permit. You know what I mean? How can you argue phasing from the first permit?
How would you know
The second permit, if they wait a year and then they come in for the second permit, I mean, I think you could come in and say, this is against the rules, you know, you're phasing. Okay, well, great, that's true. But how do you tell from the first permit? There's nothing probative about the first permit with respect to phasing.
Well, here's just a suggestion. I don't want to cut anybody off, but we still have quite a bit to do here. You know, it sort of sounds like the spirit of this is, well, maybe, you know, the town's position isn't so bad on this thing. But maybe what we could do is, you know, kind of really review this thing. And if somebody really has a feeling that there's a valid, you can use that
that's
word.
a good idea, yeah.
Yeah, reason to say that maybe the applicants have something strong to say, then maybe we could, you know, do it by email, or is that able to be done, David, or is that a violation?
Well, I guess I would prefer to hear, I mean, does anybody think any of the arguments that were put out was particularly persuasive by the applicant, by the two applicants?
No.
No.
What was your question, David?
Well, I just am questioning whether you found any of these arguments, you know, as we go ahead to try to craft something, you know, found any of these any particular argument of the applicant that you find particularly persuasive?
I didn't, and I thought Ramsey's doc, I mean, it was gigantic, but I thought it did a really nice job. I also really liked that table that he included that had the different points and the response.
Right. It's like a matrix there, yeah.
Yeah, I thought that was very helpful. I also thought it was interesting at one point, I don't remember if it was Brighton Grassroots or Save Monroe made a comment, something about the fact that Ramsey's response was lengthy, was somehow indicative of having a weak position or something, which I thought was strange.
Just from a technical standpoint.
So if the general sentiment is that we kind of feel that, you know, we should move towards the direction of supporting the town's position on this, is that fair here? Because we really got to get moving here.
I'd like to hear what Member Wright was going to say.
Go ahead.
I was just wondering, both of the applicants made arguments that they did not, you know, in their papers that they did not make tonight. So do we need to respond formally to those in our written findings? For instance, the letter of credit argument or the RG&E easement argument that really weren't focused on but are discussed in the documents. Does our approval or denial need to find a finding of fact for each of those as well?
I think, Andre, the stuff that they didn't touch on, that those are the simplest ones to do. They didn't touch on it because they know they weren't correct. I mean,
Yeah.
the letters of credit. Well, there's the letter of credit. You know, it's there. So the ones they didn't touch on were ones that they know that they don't have any, you know, leg to stand on.
But
So I think those are very easy ones because they put it in their application that we address. Well, obviously the letter of credits were issued.
Yeah. after.
And their complaint is that, well, the town didn't give me all this stuff in time, so that's why.
Right.
That the
But when-
town didn't call us and say, hey, we're issuing a permit now.
Okay.
You know, it's like,
Right,
come on.
but when they filed these, when the two lawyers did for the neighbors and Monroe, there were no letters of credit, so their
No, there were
concern was
letters.
valid,
Judy,
wasn't it?
Judy, there were letters of credit.
From the get-go?
They came and foiled the town every single piece of documentation regarding the building permits. They foiled. We're talking over, I don't know, 15,000 different pieces of information. The town couldn't turn all that around immediately.
Okay.
The letters of credit are included in the response we got from Ramsey.
Right.
Right, but my question was, were they there when these?
Yeah, Judy, that was just a timing issue. When they requested all the documents, the town gave them a bunch of documents. They just didn't have included the letters of credit. So the petitioner assumed that there were no letters of credit. When they really were, we just hadn't included them.
Right, which is a fair assumption. I mean, to
Okay.
be fair.
Right, but the fact of the matter is the letters of credit are there. They
Right,
have been posted. So let's stop at that, okay?
Yep.
May I just throw out that there are other arguments that are in their papers that they did not address.
I know some are pretty obscure. There's a couple weird ones in there. I know.
Yeah.
We will need to address those. Yeah.
Okay, that was my point.
Yeah, I can't find them right now, but I remember reading them. They're weird. There's some odd ones that are just.
Well, like one isn't odd, it's just a misreading of it, like the RG&E, the 90 days.
Yeah, but there's some more weirder ones than that.
Yeah. No, there definitely are. It wasn't comfortable saying if you didn't talk about it, we don't have to address it.
I agree, Catherine. We need to address everything that they come through. I think some are going to be very straightforward.
All right, so how are we planning to do this, folks? Because we got to make some decisions here.
Can I ask one last question though? And I thought this was true, didn't RG&E have ownership of the trail back there, the east? Because of the utilities?
RG&E's easement.
Okay,
But then it was their land. Then they just started selling off their land.
But again,
Keeping an
and
easement
to
over it.
point out the nature of the thing, sorry, but there's nothing in anything that said that they had to have the trail easements. I mean, that's what's so kind of again, kind of bending and twisting. The approval simply says they have to submit plans for the trail. It never says they have to have the easements prior to anything. So again, they had us focusing on, we didn't have the RG&E easements weren't sufficient, all that stuff. We don't need the RG&E easements to issue this permit. We simply need to have submitted the plans for the trail.
Then we will get the easements afterwards.
And that says that specifically. And then, before, I think at some point, we have to file the easements. But to issue the building permit, you don't need them.
So it sounds like there's some consensus here for which direction we would want to go. And the reason we're tabling is just to give us time to write it up and with regards to Ramsey's response, or?
Well, in addition, also to be able to respond to the late submissions from the one group. Yeah, for both reasons, theoretically.
Okay.
But more so time to respond and time to make sure that we understand each other.
Okay.
But I think I'm ready. I have enough information, a feeling for what we're doing. I think.
Okay. All right. Yeah, because we're closing in on 12, guys, and we really don't run these meetings past 12, and we've got a lot of this stuff to finish. So if everyone's generally comfortable here, not trying to browbeat anybody, but David's really got to help put some of this stuff together so that we can see it. But if
Should we
this
just
is,
table them sequentially, Dennis?
yeah, that's fine. Somebody's just got to make a
Yeah,
motion.
and just as you're tabling, just make the remark that we will allow the building inspector to address within 2 weeks any additional information that's come in from the appealing parties.
Yeah, the issues raised on that. Yeah.
Okay, so Andrea, you have the first one, please.
Got them both.
Yes, yep. Thanks for that, by the way.
Get on purpose.
I know you did. I move table application 9A-04-20 in order, and to keep the public hearing closed.
Oh,
Yeah.
close.
That's what I said, keep the public hearing closed.
Oh.
To allow the Town of Brighton building inspector to respond to any new information submitted by the applicant within 2 weeks of today's date. And I think.
That's good enough.
Yeah, I think
That's what
so.
we're tabling it for, and then we'll come back and we'll make our decision at our next meeting.
Okay. And then after we do 10A0120, I'll do the exact same motion for grassroots.
Yeah, this is for 9A0420.
Yeah,
And then
nine-
we'll do 10A02.
Yes,
Yeah.
exactly.
So this is for 9A0420. The motion is to table. Do I have a second?
For a second.
The motion is to table. Ms. Schmidt,
Yes.
Mr. Mites,
Yes.
Ms. Dale,
Yes.
Ms. Schwartz,
Yes.
Ms. Watson,
Yes.
and Ms. Tompkins Wright.
Yes.
Motion to table carries.
Okay. Next one is Cardiff Park for.
Do you just
the-
want to go, do we just want to just jump to 10A02 since?
I
we
don't
can
care.
just-
Fine. Let's just do it. Go ahead.
Go ahead then.
I move to table application 10A-02-20 and keep the public hearing closed in order to permit the Town of Brighton building inspector to submit a response to any materials submitted by applicant within 2 weeks of today's date.
Do I have a second? Somebody please second.
Yeah, me. Yeah.
The motion is to table. Ms. Schwartz,
Yes.
Mr. Mites,
Yes.
Ms. Watson,
Yes.
Ms. Schmidt,
Yes.
Ms. Dale,
Yep.
Ms. Tompkins Wright.
Yes.
Motion to table carries.
Okay, so then we move up back over to Cardiff Park. This is the driveway expansion. Any objection,
No.
Kathy?
All right. I move to approve application 10A-01-20 based on the following findings of fact. 1, the variance request is to widen the existing driveway so as to fit 2 cars side by side. 2, the expansion would be 2.8 feet from the property line where the code requires a minimum of 4 feet. 3, the granting of this variance would not appear to result in any substantial detriment to nearby properties or otherwise adversely affect the character of the neighborhood, as currently about 50% of the homes have double wide driveways facing the street. Moreover, multiple neighbors have signed a letter in support of the variance request, including the neighbor most affected by the variance. 4, there is no evidence that there would be a negative impact on the health, safety, and welfare of the neighborhood. Condition, the variance applies only to this application for widening the driveway and testimony provided and will not apply to future projects. Does it need building permit?
Number 2 is all necessary highway permits shall be obtained.
Highway permits, thank you. That's it.
Have a second?
Second.
Motion is to approve with conditions. Ms. Tompkins Wright,
Yes.
Ms. Dale,
Yes.
Mr. Mites,
Yes.
Ms. Watson,
Yes.
Ms. Schwartz,
Yes.
Ms. Schmidt.
Yes.
Motion to approve with conditions carries.
Okay, the next one is Commonwealth Road. There's a,
Pool.
Holy
yeah.
pumps.
And that's kind of a weird lot, and I'm not sure what else you're gonna really do there.
You
but-
can't. I know, it's very, very confirmed. Yeah.
Okay, is there
Okay.
anybody object? Okay, Judy, go ahead.
Okay. I move that we approve application 10A-0320 based on the following findings of fact. 1, this is a corner lot, which by its nature requires a variance for most modifications to the property as in this case where the side yard is the front yard by code. 2, the variance is minimal as it only encroaches 4 feet into the front yard setback. This is necessary because of the dimensions of the backyard being longer north to south and the front yard faces north. 3, the proposed pool will not really be visible during the season of use because of substantial vegetation on the north side of the property. 4, there currently is a 3.5-foot picket fence along the Ashbourne, that is unobtrusive because of the substantial vegetation. Therefore, there will be no perceived difference with the installation of the required 4-foot fence. Oh, conditions, sorry. 1, this variance only applies to the location of the proposed in-ground pool and the required 4-foot fence as presented in testimony and written application. 2, all necessary building and planning approvals must be obtained.
Did you say all necessary building permits shall be obtained?
Yes.
Second.
Do we need to, I don't know, do we need to be specific about the new fencing shall not be placed in the town right away? Or don't you think that's necessary?
It's illegal if they do, isn't it?
I mean, they can't do it, but.
Yeah, it's a requirement that you can't.
Yeah. they
Yeah,
just can't
I don't
do it.
think you need to state
Okay.
against something that's.
All right, who had the second?
I did.
The motion is to approve with conditions. Ms. Schmidt,
Yes.
Mr. Mites,
Yes.
Ms. Vale,
Yes.
Ms. Tompkins Wright,
Yes.
Ms. Watson,
Yes.
Ms. Schwartz.
Yes.
Motion to approve with conditions carries.
Okay, the next one is over on Pelham Road. That's the garage addition. Any issues here?
No.
Jennifer?
I move to approve application 10A-04-20 based on the following findings of fact. Number 1, the proposed variance is the minimum needed to provide a second garage bay in that the addition is for a single car with the smallest footprint possible. Number 2, the proposed addition will not result in a substantial change in the character of the neighborhood or pose a detriment to nearby properties. Other houses in this neighborhood have similarly situated rear setbacks or similar additions. Also, the proposed addition will not be front-facing or easily visible from the street. Number 3, no alternative garage placement exists that would not require a variance. The proposed location is the least visible and the most pragmatic as compared to the other options that the applicants explored. Conditions. Number 1, this variance will apply only to the project as described in the application and plans on file. In particular, it will not apply to projects considered in the future that are not in the present application. Number 2, all necessary permits and approvals shall be obtained.
Second.
Motion is to approve with conditions. Mr. Mites,
Yes.
Ms. Tompkins Wright,
Yes.
Ms. Dale,
Yes.
Matt,
Yes.
Ms. Schwartz,
Yes.
and Ms. Watson.
Yes.
Motion to approve with conditions carries.
Okay, next is Oak Lane where the gentleman is trying to put a garage addition there into the setback. Any issues there? Yeah. Jeannie?
No issues there. This one's mine. Okay. Motion to approve application 10A0520 based on the following findings of fact. Number 1, the applicant is seeking to add a new 2-car garage versus their existing 1-car garage, and the applicant's home has non-conforming setbacks. Number 2, the difficulty necessitating the variance request cannot be solved in another manner not requiring a variance, as the existing driveway is along the west property line and there is no other location on the lot that would work for a 2-car garage. 3, the existing rear and side yards have existing non-conforming setbacks, and the applicant's request for the proposed 24-foot garage width is the minimum necessary for a 2-car garage and would be an additional 2.6 feet into the rear setback and an additional 3.12 feet into the side yard setback. Number 4, the variance, if approved, will not result in a substantial change in character to the neighborhood or detrimentally affect surrounding properties, as several nearby homes are similarly close to the highway concrete wall, and the nearest adjacent neighbor's home will still be over 60 feet away from the proposed structure. 2-car garages are typical for many homes on the street. Conditions, approval granted based upon application submitted and testimony given.
Second.
2, all necessary architecture review board approvals and building permits shall be obtained.
Thank you.
That's why I seconded it.
Is that why?
Okay.
The motion is to approve with conditions. Ms. Schwartz,
Yes.
Mr. Mites,
Yes.
Ms. Schmidt,
Yes.
Ms. Watson,
Yes.
Ms. Tompkins Wright,
Yes.
and Ms. Dale.
Yes.
Motion to approve with conditions carries.
The next one is the small shed over on Midland Avenue. Any objections there?
No.
Dennis, I'd like to point out that while we had the meeting up, there's a chat message that was placed from a neighbor, Ian Solinsky. While it's not the most clear, to me, it looks as if he is saying he doesn't like it because he can see it. I'm adding the word he doesn't like it.
I think there's not a value judgment. I think he was just correcting the record because she said nobody could see it. I didn't read the comment as objecting because he never said that he objected.
No, I just said it's written in a way you can't really tell what the point is, but he is saying that he can see it. And I took that as a negative, but it could just as easily be a correction.
Okay. Is anyone concerned about that or?
No. Yeah, even if he objected to it, where else would they possibly put a shed?
And they don't even have a garage.
There's
It's a
no
little
yard,
over.
no.
That shed is better than having stuff spilling out all over your yard.
Well, and no
Yeah.
garage, I mean, you know.
Okay, let me get going here. All right, I move we approve application 10A0620 based on the following findings of fact. 1, the house was built adjacent to the rear property line, which would not allow for a rear yard shed. 2, since the house has no garage or garage structures, a shed is required to meet the needs of the applicant to store lawn equipment, etc. 3, placing the shed in the side yard at the same elevation to the house will be in keeping with other structures within the neighborhood. 4, no negative effect on the character of the neighborhood would result from the approval of this variance, since the distance from the street and vegetation mitigate its location. Conditions 1, based on testimony given and plans submitted as to the specific location of the shed. And what do they need for permits, Rick? I don't know.
Building, all necessary building permits shall be obtained, number 2.
Okay.
Second.
Motion is to approve with conditions. Ms. Tompkins Wright,
Yes.
Ms. Dale,
Yep.
Ms. Watson,
Yes.
Ms. Schmidt,
Yes.
Ms. Schwartz,
Yes.
Mr. Mites.
Yes.
Motion to approve with conditions carries.
Okay, the next one is the COVID awning for Canal View here.
I don't have a problem with it, but my only question is whether or not it's considered a sign because it's got a great big logo on the front.
Yeah, you know, they need sign review for it. But it meets code for additional signage on that side of the building. I mean, the building has a couple sign variances, but those are for variances that are in the parking lot side of the building.
Mm-hmm.
When you look at this, they meet the sign requirements for the front of that building. with the logo on it. I mean, you guys don't like it, you can tell them to take the logo off.
Wouldn't it have been nice to include it though in the
Oh,
application?
it was included. Oh, they actually took
What?
one off the side. It was
Oh.
included in the elevation. Elevation.
But
shows the
in
logo.
his presentation, he didn't say anything.
Oh,
Yeah, he didn't address it at all, right?
No.
right.
And
But they did have one on that side elevation. They had one, and we told them they better get rid of that or they're gonna need a variance. So they got rid of that one.
Well, I guess what we could do is we could condition this thing if we want to approve it, subject to them obtaining the ARB approval for the signage, because without it, then they could put it up, but not with the U of R thing on it.
I mean, can I just point out, it is a practical thing, if I'm driving up and I'm coming to like kind of a drive up medication for my heart and I'm nervous about the pandemic, I would want to know that that's where I'm supposed to be.
I don't have a problem with it. I just wanted to make sure it wasn't violating anything.
Right.
No, we looked into it.
Cool.
Okay.
All right. I move to approve application 10A-0720 based on the following findings of fact. 1, the variance request is to allow an awning to extend 12.2 feet into the 75-foot front setback required by code. The proposed awning will allow for curbside delivery of medications to cardiac patients during inclement weather and allow for appropriate social distancing during the current COVID-19 pandemic. 3, the applicant explored alternative means of delivering medications to its clients, but determined that this was the best solution as it did not require a change to the drive lane. 4, the granting of this variance will not produce an undesirable change in the character of the neighborhood or be a detriment to nearby properties, as the property in question is a commercial space, some of which have canopies and or awnings similar to what is being requested in this application. 5, there's no evidence that there would be a negative impact on the health, safety, and welfare of this development. Conditions, the variance applies only to the awning as described in the application and testimony provided and will not apply to future projects. I couldn't think of another building permit that you needed, so that's the only condition I had.
I would just put the standard all necessary architecture review board approvals and building permits shall be obtained.
Thank you.
Second.
Judy.
The motion is to approve with conditions. Ms. Dale,
Yep.
Mr. Mites,
Yes.
Ms. Watson,
Yes.
Ms. Tompkins, right?
Yes.
Ms. Schwartz,
Yes.
Ms. Schmidt.
Yes.
Motion to approve with conditions carries.
Okay, the next one is that partially screened porch on the front of the house on Dunbar Lane. Any objections there?
No.
Okay, Judy?
No. Rick, what's what's that for?
I personally don't like it, but that's just me.
Oh, okay. Yeah, but I love my front porch, so I'm partial.
Well,
Anyway,
I'd rather see an open front porch.
an
than
open,
a
okay,
screened
then
front,
okay.
but, you know.
I move that we approve application 10A-0820 based on the following findings of fact. 1, though the variance seems substantial, 10 feet into the required 60 feet front setback, the result will not change the character of the area as the house is on a pie-shaped lot with a more expansive width, thus minimizing the new front setback. 2, in order to provide practical usage of the proposed porch, the dimension of the 12-foot depth is required. 3, the proposed porch will add character to the house and blend well as all materials will match the existing. 4, the rear of the house does not lend itself to a porch, so it's in the front and will be open with an open look as much as possible. And then conditions number 1, This variance only applies to the proposed porch as presented in testimony and written application. 2, all necessary planning and building permits must be obtained.
Can I just be a little more, can we be a little
Sure.
more specific on this, the porch itself? And can we say something like only to a screen/open porch?
Yeah, well, that's why I said it was gonna be open as much, but okay.
I just want to make it a condition, so at some point in time, somebody doesn't decide that they're going to close the entire thing.
Okay, so a third condition would be that this porch
No.
must be a screened open porch?
The first condition, just kind of, when you're saying it, just make it fact that it's applies
so-
only to. Just be
Okay.
more specific with the, on your first condition. just be
Oh,
more
okay, this
specific.
variance only applies to the proposed porch as presented in testimony and written application being an open screen porch.
In particular.
In
shall be
particular, an open and screen porch.
An open/screen porch.
All right. Rhoda, I hope you got that.
I think we wanna, and also, well.
What else?
And number 2, all necessary architecture review board approvals and building.
Oh,
permits.
sure, because it's in the front of the house, right.
Right.
Thank you. Forgot that one.
Have a second?
I do.
Can't.
I'm sorry, Andrea?
Kathleen can have it.
Oh, Kathleen got it? I wasn't-
I'm not
I
going
wasn't
to
sure
wrestle
who
you
got it.
for it.
The motion is to approve with conditions. Mr. Mites?
Yes.
Ms. Watson?
Yes.
Ms. Dale?
Yes.
Ms. Tompkins, right?
Yes.
Ms. Schmidt?
Yes.
Ms. Schwartz?
Yes.
Motion to approve with conditions carries.
Okay, the next one is Ryan Cliff with the 2-story addition. Any issues there?
No.
Okay, Andrea.
I move to approve application 10A-09-20. All is described in the application and plans on file based on the following findings of fact. Number 1, the granting of the requested variance will not produce an undesirable change in the character of the neighborhood or be a detriment to nearby properties. The 2.3-foot extension into the side setback will be relatively shielded from view both by passersby and by the neighboring property owner due to a line of shrubbery along the south side of the property. Number 2, the requested variance is not substantial given the aforementioned shrubbery screening and the fact that the property will still maintain a side setback of 6.7 feet. Number 3, the benefits sought by the applicant cannot reasonably be achieved by any other method. Applicant testified as to the need to extend the house and garage in this specific location, in part due to limited circulation of vehicles parking in the garage, and in part due to the location of the garage and where it connects to the home. Number 4, there is no evidence that the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. Conditions. Number 1, the variance granted herein applies only to the addition described in the location as depicted on the application and in the testimony given. And number 2, all necessary permits and architectural review board approval must be obtained.
Second.
Motion is to approve with conditions. Ms. Schmidt? Ms. Schmidt?
Oh, yes. I'm sorry. I thought you said somebody else.
Yes?
Yes.
Mr. Mites?
Yes.
Ms. Dale?
Yes.
Ms. Schwartz?
Yes.
Ms. Watson?
Yes.
Ms. Tompkins, right?
Yes.
Motion to approve with conditions carries.
Okay, the next one was the person who didn't show. Do you want to just hold it over or what?
You know, normally I would say, yeah, we very rarely do something without an applicant presenting the project. But there's really nothing changing other than them erasing the lot line here.
Yeah.
I mean, it's not like they're building anything. It's
Right.
not like they're doing anything other than.
Okay.
Can I just ask one question that I would have asked the applicant? Is my interpretation correct that if they weren't combining those two lots, their current setback is code compliant, right?
Yes,
Okay.
I believe so.
Good.
It has to be 15% of 72.
That's what I calculated.
Yeah, so it does meet code.
So we don't need to save it? You can take care of it? Or what?
No, we either have to table it for
Oh.
representation, or you guys got to make a decision on it.
Oh, okay.
I mean, normally we don't do anything without having representation.
Yeah.
This is one of these cases where there's nothing really to be said because nothing's changing on the lot other than the removal of the lot line.
Right.
David, are you out there?
Yeah, I'm here.
What do you think about this application if we were to make a decision without the applicant having presented it?
It wouldn't, I don't see who you're prejudicing.
So you wouldn't have a problem with us making
No,
a
I
decision?
don't. I don't think so. I just don't think anybody's prejudiced by it. Who's going to complain?
Right.
Nobody.
Right. And, you know, it was a long meeting, it's COVID. I mean, people could, you know.
All right, let's do it.
Yeah, I was just
Let's
assuming.
do it.
Anything over.
Go on, Jennifer.
I move to approve application 10A-10-20 based on the following findings of fact. Number one, as a single lot at 1050 Highland Avenue, the existing structure meets the town code side setback requirement of 15% of the lot width. Combining the two lots together increases the overall lot width and therefore increases the required side setback. Number two, the proposed variance will not result in any change in the character of the neighborhood or pose a detriment to nearby properties. The setback of the existing structures are not changing and no additional structures are being built. Number three, the applicants are requesting a variance for the sole purpose of ensuring their existing home complies with town code after the two lots are combined. No alternatives exist to complete the lot consolidation without a variance, and this difficulty was not self-created. Conditions,
I
number
don't know if you need any conditions, to be honest with you.
none at all?
I can't, what are we conditioning?
All right, no conditions, you're approved.
I second.
The motion is to approve. Do I have a second on that?
Yeah, Judy.
Motion is to approve. Ms. Tompkins, right?
Yes.
Ms. Dale?
Yes.
Mr. Mites?
Yes.
Ms. Schmidt?
Yes.
Ms. Schwartz?
Yes.
Ms. Watson?
Yes.
Motion to approve carries.
Here, the next one is the PET scanner over at U of R, or the MRI scanner, sorry.
Okay, that's me. Motion, oh, I assume everybody's fine.
Yeah, go ahead.
Okay, motion to approve application 10A-11-20 based on the following findings of fact. Number one, the request is to install a temporary MRI trailer next to the existing building. A temporary covered walkway will connect the trailer entrance to the building for patient transfer. The trailer and walkway covering will be removed within 2 years of installation. Number two, the applicant plans to use the trailer facilities to enable them to clear a backlog of patients created by the pandemic and who could not receive or complete necessary medical imaging. Number three, granting of the request will not result in a substantial change in character of or be detrimental to surrounding properties. Any increase in traffic due to the use of the trailer will be offset by declines in traffic due to large portions of the workforce working remotely, and the MRI trailer will not be located near any homes, roadways, or public uses.
You might also want to say, Gene, that the trailer isn't taking up any parking.
Oh, that's a good point. Thank you. Okay. How
I
about?
think you can just continue that.
Yeah.
particular
So
thought.
also the proposed trailer will not reduce parking on site
Since it is located
since it's located.
outside of the parking lot.
Thank you. That's very helpful. Also, the proposed trailer will not eliminate any parking spaces as it is located out, as it's planned to be located outside of the parking area.
There you go. Hey,
Thank you for your help.
you're welcome.
Conditions, installation of the temporary MRI trailer and covered walkway is to be installed at the location shown in the application and shall be removed within 2 years. I don't know if they need any of the other things.
Do we want to put a condition on there that they got to replant these trees?
Oh,
right.
thank you. Thank you. They did say they would. So, okay. So,
Yes, they did say they would, and I'm not saying they won't, but I don't think it hurts.
no, sure, we'll grow trees. Okay, so condition number 2, applicant shall replant any displaced trees on the property.
Second, Judy.
I just want, I'm not adding one, I just want to go back and verify, number 1, trailer and awning shall be located as per plans. And you want to say, and shall be removed within a 2-year period?
Well, they said.
I don't mind the 2 year, if you want to give them 2 years, I don't have a problem with
Oh,
that.
that's true. They'd asked for 18 months.
They asked for 18 months.
I would just assume give them 2 years because with the pandemic and who knows but I don't feel strongly about it. If you guys, they asked for 18 months, we could just give them 18 months.
Guys, what do you think? Do you want to say 2 years or 18 months?
I would do 2.
I get a little, my only feeling is I hate giving people more than what they ask for.
Okay, then go with 18 months.
Okay, let's go with the 18. Let's go, because that's normally what we do. We don't add usually on, so.
The only thing is if it can't get picked up in time,
Well, we're not going to be that stringent about it.
Yeah.
Oh,
Judy.
all right.
I mean,
Let's move on.
if it goes 19 months, I'm not going to go out there and
Okay,
slap them on the wrist, all right?
Rick, will this need ARB approval?
I don't think so because we're going to cover the canopy as part of the temporary and revocable use permit.
Okay.
So no, I wouldn't because the canopy is going to go when the trailer goes.
Great. Yeah.
If they want to make the canopy permanent, then they'll have to come in, get a permit for it, and also get ARB approval.
Okay.
But they're keeping the concrete pad and you're all right with that?
Yeah, because there's really nothing, they could put a concrete pad there now without any needed approvals.
Okay,
Who got the second on that? I'm sorry.
I did. Judy.
The motion is to approve with conditions. Ms. Schmidt,
Yes.
Ms. Watson,
Yes.
Mr. Mites,
Yes.
Ms. Tompkins Wright,
Yes.
Ms. Schwartz,
Yes.
Ms. Dale.
Yes.
Motion to approve with conditions carries.
Okay, the next one is just to extend the building permit on Town Line Road. I move we approve application 10/8/12/20 based on the following findings of fact. 1, the applicant has obtained a user for the proposed building and is finalizing construction plans. 2, no changes in the original plans or the variances approved in 2019 have occurred. And 3, by testimony, the applicant is intending to begin construction in the fall of 2020. And just one condition based on testimony given and plans resubmitted.
Can we just say that all previous conditions shall apply? Just all
Okay.
previous conditions shall apply?
Okay, all
One.
right, so number 2 and number 2, all previous conditions shall continue to apply. Okay.
Do I have a second?
Oh, I'll do it, Judy.
Motion is to approve with conditions. Ms. Tompkins Wright,
Yes.
Ms. Dale,
Yep.
Watson,
Yes.
Ms. Schmidt,
Yes.
Mr. Mites,
Yes.
and Ms. Schwartz.
Yes.
Okay, the next
Motion-
one is the generator.
Motion
okay.
to approve with conditions carries.
Okay, thank you. Next one is hibiscus for the generator. Any issue there?
No, it makes sense. I mean, the utilities are right there. And when I stopped, she made a very valid point that where it's placed, it's further from the neighbor than if it were probably in the backyard. I mean, it's quite a distance from the,
Yeah.
you know,
it's
on the
got
side.
that strange driveway thing. Okay. All right, Kathy?
I move to approve application 10A-13-20 based on the following findings of fact. 1, variance request is to allow a generator to be placed on the north side yard where the code requires generators to be placed in the backyard. 2, there's not sufficient room to place a generator in the backyard due to an existing pool, electrical lines, and a shed. The granting of this variance would not appear to result in any substantial detriment to nearby properties or otherwise adversely affects the characters of the neighborhood, as the proposed generator is smallish in size, being 48 inches by 25 inches by 29 inches, and will be well hidden by existing trees and vegetation. 4, there's no evidence that there will be a negative impact on the health, safety, and welfare of the neighborhood. Conditions: the variance applies only to this application for placement of the generator on the north side yard, and testimony provided regarding the same, and will not apply to future projects. 2, the homeowner shall continue to maintain landscaping around the generator so as to shield it from the street. And I wasn't sure about how to phrase this one, but all requirements as to how far away from the house windows, doors, and vents must be complied with.
This all necessary building permit shall be obtained. That's how we
Okay.
verify that.
Okay.
So number 3 is all necessary building permits shall be obtained.
Second.
Motion is to approve with conditions. Ms. Schwartz,
Yes.
Ms. Nail,
Yes.
Mr. Mites,
Yes.
Tompkins, right?
Yes.
Ms. Watson,
Yes.
Ms. Schmidt.
Yes.
Motion to approve with conditions carries.
Okay, then we got the first of the final two on Elmwood Avenue. The first one is the garage addition.
Right.
Any issues there?
Nope.
Judy?
Okay, I move we approve application 10A-14-20 based on the following findings of fact. 1, this variance of 2.5 feet into the existing 36.1 feet rear setback is minimal, even though a 60-foot setback is required by code. There will be no change to the character of the neighborhood, as the garage will not be visible from the street, as this is a flag lot. There is no other option to achieve the desired result for the applicant without a variance due to the existing garage and orientation of the property. The construction of the existing garage was permitted with a variance when the home was constructed in 1983. The terms of that variance do not apply to any further additions.
Judy, I don't know if that's a true fact.
What? Well, he told me.
I don't know when they built the house, whether or not it got a variance or, you know.
When I went out, that's what
Well,
Sean had said.
They got a variance for that addition just a couple
All right,
years
then I'll
ago.
leave it out. Then,
Yeah, to take that
scratch
whole finding out.
okay, we'll scratch it. Okay. Conditions, this variance only applies to the rear setback of 2.5 feet as stated in testimony and written application. And 2, all building and planning approvals must be obtained.
All necessary building permits shall be obtained.
All right, all necessary. I leave that word out, sorry.
Do I have a second?
I'll second.
Who got that? I'm sorry.
That was me,
That was you?
Andre.
Yep. Motion is to approve with conditions. Ms. Schmidt?
Yes.
Ms. Watson?
Yep.
Mr. Mites?
Yes.
Ms. Dale?
Yep.
Ms. Schwartz?
Yes.
Ms. Tompkins, right?
Yes.
Motion to approve with conditions carries.
Okay, and the last one is the last one on Elmwood Avenue is the addition going into the rear setback. You know, filling in that little
Yeah,
devices. Yeah.
that's smart. Yeah.
Yeah.
Okay, I move to approve application 10A-15-20, all as described in the application and plans on file, based on the following findings of fact. Number one, the granting of the requested variance will not produce an undesirable change in the character of the neighborhood or be detriment to nearby properties. The proposed home expansion extends only an additional 3 to 4 feet into the already existing rear setback, and due to the location will be unnoticeable from any public right-of-way or from any residential neighbors, and likely not noticeable from any commercial neighbors as well. Number two, the requested variance is not substantial, given that it represents less than a 7% increase in the setback's current nonconformity. Number three, the benefit sought by the applicant cannot reasonably be achieved by any other method. And in fact, any expansion of the home in any other location is likely to have a greater effect visually to nearby properties. Number four, there is no evidence that the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. Condition number one, the variance granted herein applies only to the addition described in and in the location as depicted on the application and in the testimony given. And number two, all necessary permits and architectural review board approvals must be obtained.
No architecture review board is required for this. So just all necessary building permits shall be obtained.
It's in the back, that's why.
Right, it can't be seen from the road.
Got it, okay.
Okay.
All
That was-
necessary permits must be.
You have a second?
Second, Judy.
The motion is to approve with conditions. Ms. Dale,
Yes.
Mr. Mites,
Yes.
Ms. Schmidt,
Yes.
Ms. Watson,
Yes.
Ms. Schwartz,
Yes.
Ms. Tompkins Wright.
Yes.
Motion to approve with conditions carries. Thank you, everybody.
Thank you.
Thank you.
I will kind of, again, warn you, I have a feeling November's gonna be another trying month.
Oh,
We have some use variance situations that we're gonna be dealing with. So, that could be,
yep.
Is
a
there ever,
challenging month also.
Rick, is there ever a time limit on applications or a cap on the number